time, they didn't know, I guess, were not aware that defendant Young was an actual suspect. They just knew the car because the car, Your Honor, is actually registered to her mother.
Right.
So for them, for purposes of them, they didn't realize that she was a suspect until after the conversation had started.
Okay. Well, I guess we'll develop more. But what I'm hearing you say, importantly for working through the motion to suppress, is that of all the various statements that Ms. Young made, the only one that you'd seek to use if this goes to trial would be her statement to Cobb detectives. Yes. She may well have been at East Point, but it was that final interview with the Cobb detectives.
Yes, Your Honor.
Okay, got it. Ms. Mignot, are you representing Ms. Young in her Cobb County case?
I am not, but full transparency with the court, the family is intending to retain my services to file a motion to withdraw the Cobb County plea that has been interjudged. So this case has become quite complex once discovery has actually been unearthed. I also only have 2 interrogation videos, and according to my investigation, they were all done together. So it's soften her up, get a statement without Miranda, bring in the 2 Cobb County detectives, let them do the Miranda, get her to say almost the same statement she made, and then go, voila, these are Miranda statements.
But you have all that on video?
Correct.
Okay. You don't have video for any interaction Ms. Young may have had with the Atlanta police officer when the car got pulled over?
No, Judge, I didn't see that.
Okay. I don't know that it exists, but it doesn't sound like that's anything the state's planning on using. It doesn't mean you're not entitled to it because they're not going to use it. That can be follow-up conversation between you and Ms. Clark.
Yeah, that's another issue, is that we were waiting on the scene video, the video of the incident location, which.
When you say incident location, meaning the car being pulled over? Because my understanding is that Ms. Young comes into contact with law enforcement not right after the armed robbery, at the scene of the armed robbery, but this car is a car of interest and it gets pulled over. Ms. Young is in it, may even be driving it, no matter, she's in it. As I think Mr. Furlow is, and there's a third guy, Belcher. But anyway, it's not that the car was stopped right where the armed robbery occurred. So when you're saying at the scene, I want to make sure I'm following you.
So what the documents infer is that Ms. Young was at the location. There's video footage from the Family Dollar at the location. And if you read into it, it appears as if she's sitting in the car waiting for the armed robbery to be completed. Individuals jump in the car, she takes off. That's the inference.
Okay, the getaway driver.
The getaway driver. And when we asked for that video footage, I believe, in fairness to Ms. Clark, Mr. Dion Peoples advised the court that he was going to contact his investigator and he was going to get that information and turn it over to us. Because if the court recalls, we were at a final plea calendar when our client had received an offer that she was seriously considering. And when we said, hey, where's the evidence that I need to show to my client so that I can inform her of any defenses, which I'm required to do based on the evidence, or any bad things based on the evidence. And Mr. Peoples advised us, and that's why the court was respectful enough to hold on to the offer, allow the matter to be continued. And when I reached out to the state and said, hey, where is the footage that I can show my client so we can go forward?
Right.
I was advised, we're going to contact East Point. In fact, Mr. Peoples said, Ms. Clark is now on the case. And then Ms. Clark said, we'll contact the investigators. Same thing I heard again. And then finally, I got an email stating, we don't have that video. East Point has it. To this day, I don't know if they had it and lost it, they never had it and they lied, or what happened to it. It just doesn't exist. And,
okay.
And evidence cannot exist. So
right.
We decided based on what the evidence is now that, wait a minute, somebody wasn't Mirandized here. And now all we're doing on the same day is, oh, okay, so we'll just do it after we get the statements. So according to our investigation, it's the same day. And
okay.
It's right there in the East Point Police Department We just bring Cobb over and say, hey, have at her. And Cobb does their thing. And all of a sudden, she moves from, we don't know if she was involved, but she is in custody the entire time. In fact, she's in handcuffs, not free to leave. So-
Okay, well, you're now getting way ahead of things. So we're going to hear what the witnesses have to say. And if your client testifies, what she has to say. I just trying to sort out all the moving parts here because this has never been real clearly presented to me, other than Mr. Furlow has already pled and has admitted that he was involved in an armed robbery and that he's connected to Ms. Young. So it's a little more complicated for Ms. Young than maybe you're making it sound. But he's down the road where he's going to be for a fair amount of time. Okay. Do you mind, investigator, getting Mr. Abate just to poke his, and Ms. Gordon, poke their heads in? Thank you. Hey, good morning. I didn't want to have you guys wait around. We're about to start a suppression motion, the evidentiary part of a suppression motion, which will take a little bit of time. If you all know that Ms. Brown-Moore's case is not getting sorted out today, I don't mean to make you all wait, and we could, in 3 minutes, get on the record what the state's offer is and that Ms. Brown-Moore is not interested in it. Then you're not stuck here until we take a break in the suppression hearing.
That'd be great, Judge.
Is that where we are?
Yes.
Okay.
Is
All
that
right.
right here?
She is. Did she get brought up? Yep, she's here. She's up. So we're going to pause in the record for Ms. Young. And you can stay right where you are, Ms. Young, because I'll have Ms. Brown-Moore and Ms. Gordon go to the podium.
Great. Great.
I apologize. Good morning, Jen.
Good morning. Hey, Ms. Brown-Moore, if you'll come up to the podium, please. All right, Ms. Rivers, we are going to change records real briefly. We're going to shift to 23 SC 186557, State versus Brown-Moore. Ms. Brown-Moore is here at the podium with her lawyer, Ms. Gordon. Mr. Abate is here for the state. Today is the final plea date for Ms. Brown-Moore. And what that means, Ms. Brown-Moore, is today is the last day if you received an offer from the state that is something less than what's charged in the indictment. If you wanted to pursue that, if the sentence I gave you was more severe than what Ms. Gordon asked for, you'd have the ability to step back from that and say, no, thank you. I was interested or was prepared to go forward with what my lawyer advocated for, but not judge the sentence you imposed. This process is a little more meaningful if, say, you were charged with burglary and the state is recommending 5 years and Ms. Gordon argues for 2 years for you. And I say, I think 3 is the right answer. That you can see how there's some movement there. As you know, you're charged with murder. And so if the state is offering to let you plead to the indictment, I don't have a whole lot of flexibility. The sentence is life, and there's a little that can be added onto it in terms of the firearms charge, but it's nothing that is particularly meaningful. But I still want to have this conversation because it allows me to know that we ought to get your case put on a trial calendar. And I wanted Ms. Gordon to be here with you because her schedule gets a little complicated soon. And so I want the 3 of us to talk about how we ought to manage getting you on a trial calendar. You actually are on a trial calendar right now in front of another judge, but we're not going to get to the case. I just wanted to have the possibility that there could be a trial before Ms. Gordon was going to be out for a little bit. And that was the one spot I could find. But I'm sort of at the back of the line in that calendar, which means you're at the back of the line as well. So I'll see if you follow everything I said in just a minute. Let me find out from Mr. Abate what the state's offer is.
State's offer at this time is life, Your Honor.
Okay, so it would be a plea to the indictment.
That's correct.
Okay, as I forecast, Ms. Brown-Moore, the offer is life. You face the possibility of life without parole if you go to trial and are found guilty. That would be a sentence I could impose. So right now the state is offering life. I don't mean to make that sound like it's a whole lot different, because as I'm sure Ms. Gordon's told you, the way parole works right now, that's 30 years at least, as a huge number. Life without parole is huger because it means what it says. Right now the state is offering life. Another option is life plus 5 because of that firearms charge. So the state is offering the lowest thing it could without reducing any charges. And I don't describe it that way to say you should feel like they're being generous. They know what their evidence is, and that's their offer. Do you have any questions about what the state's offer is?
So I have a firearm charge now?
Not now. It's always been on there. There's an allegation that you possessed a firearm during the commission of the shooting of the victim. It's always been in the indictment. And it's something that is we call it a +5. It's a sentence of 5 years that has to run consecutive to any other sentence you get. But it can be probated, it can be suspended. So it effectively could go away. I don't want you to be distracted by that. That's always been in the indictment. That's not obviously the big part of the indictment. The big part is the shooting that resulted in the death of the victim in this case. And I've got to hear a lot about it because of the immunity hearing. But yes, there is count 4 of the indictment is this firearms piece. I just added that in the discussion so that you understood the state's offer is the lowest offer they could make without reducing a charge. Of course, they're able to reduce charges, and I am confident that Ms. Gordon has been engaging with Mr. Abate to say this should be voluntary manslaughter or involuntary manslaughter, or you should dismiss it, all those things. But the state's not required to do that. I'm sure he listened, and he respectfully disagrees with your lawyer's perspective on that. So where the state is right now is that if you entered a plea, it would have to be to what you're charged with and not something less than that, which would mean a sentence of life. And then that 5 years, I would just run consecutive, but suspended. So that's where we are. And none of this should be a huge surprise because I know your lawyer has been talking with Mr. Abate, but it's all very heavy, whether it's a surprise or not. I need you to tell me whether that's something you want to go forward with. In other words, plead guilty to the murder, or if instead you would like your case put on a trial calendar so that you and Ms. Gordon or one of Ms. Gordon's colleagues can argue to the jury a lot of what Ms. Gordon argued to me, that it's a much more complicated picture than murder.
And Judge, if I may, for the court's knowledge, as well as for my client, because we haven't had a chance to speak this morning, I just want to make clear that Mr. Abate, and this is not to disparage or throw Mr. Abate under the bus in any way. I know that he's been very busy with a lot of stuff. I had emailed him a few times prior to today to try to discuss an offer in this case. We have not actually had an opportunity to have a meaningful discussion about an offer. I spoke with him in the hallway just now, and that's when he relayed the life offer and said, you know, I'm willing to hear a counter to that, but then we got called back into court. So the reason, you know, Destiny is hearing this life offer for the first time today, because of that. So I just want to put that on the record.
That's helpful context. I appreciate that. Ms. Brown-Moore, important thing for you to know, Ms. Gordon is free, and I'm confident will continue to work with Mr. Abate to see if there is something less than life that the state is willing to pursue. So conversations aren't over after today. This is just a way station we have to work through on any case, yours and any other one of them, so that I can make a record of here's what the state's offer was. The defendant said, no, thank you. And then I can put it on a trial calendar so that we can focus on either getting closure for everyone, you and the victim's family, because a jury decides guilty, not guilty, or with the pressure of trial on the state's shoulders and your lawyer's shoulders, people see that there is a middle ground. And so maybe it is a plea to voluntary manslaughter. And the state's recommending X and your lawyer recommends Y, and I come up with what the sentence is. Just the difference is after today, whatever that sentence is, even if it's more than what Ms. Gordon advocates for, that's the sentence you get. Just like if you went to trial. If you go to trial and a jury finds you guilty, I will 110% listen to what Ms. Gordon has to say about a reasonable sentence. I may disagree and impose something that's higher than that. And that will frustrate you, but that wouldn't be a reason for you to say, oh, the deal's off. That's just not how it works. Okay? Do you have questions about anything we've been talking about?
So you agree after hearing my case, my story, my testimony, that this is a fair offer?
So that's not my role to decide what's fair or not fair about the state's offer. They are 100% in charge as to what they offer. Your lawyer's job is to help maybe add perspective as to what might be fair, given all the things that came out during the immunity hearing. But my opinion about whether the offer is fair or not isn't for public consumption. I certainly will share with you and Ms. Gordon and the state what I think is fair if we get to the point of you entering a guilty plea or a jury saying you're guilty. Of course, if a jury says you're not guilty because they find that this was an act of self-defense, then we don't need to talk about sentencing. And we wish you the best as you move forward and try to put this behind you. But we're not there yet. Where we are right now is that's the state's offer. I think you understand what the state's offer is. Is that correct?
Yes.
Okay. I didn't realize, and I apologize, that that wasn't something you and Ms. Gordon had a chance to discuss because Mr. Abate, who's been running in about 100 different directions, hadn't conveyed that to Ms. Gordon. I'm okay taking a break for you all to talk about it. I'd be surprised if you think that Ms. Gordon, you'd get a lot of traction talking with Ms. Brown-Moore about a plea to something that would involve a life sentence. So I don't want to rush anyone, but if you want to take a break, you guys can talk. We won't pivot back to this for about an hour.
Judge, we're not going to enter a plea to life today.
Okay, got it. Then last thing we need to talk about is, Ms. Gordon, how you want me to schedule this. I have 2 more trial calendars this year that I could put it on. I could do it as an addendum to the November. And then we have I think it's a 1 week. There's a December trial calendar that we could put it on. You've made clear that those could be complicated dates for you. And so I don't know if you and Ms. Brown-Moore have decided when it is trial time, it's going to be Rachel Gordon as trial counsel, or Ms. Brown-Moore is anxious, understandably, to have that trial. And so I ought to start getting this on the first available as opposed to your first available.
Ms. Brown-Moore and I did have an opportunity to talk about this a week or 2 ago, Judge. I will say that probably 3 or 4 weeks ago, I felt very confident that I could try this case before I go out on maternity leave. That is no longer the case. I'm about 9 months pregnant at this point, and I just don't think I have the stamina for it.
Yep.
Destiny has expressed a desire for me to be lead counsel when this case does get tried. That being said, I don't know what the court's schedule is, but I would request, if possible, that the court place this case on a trial calendar as early as possible in March of 2024.
Okay. If you would send an email to me and Ms. Nelson and Mr. Abate with that request, that means I'll remember it. We haven't started putting together the March trial calendar. We have trial calendars every month, Ms. Brown-Moore. So you don't need to worry like, oh, if you miss the March one, then it will be August of next year. There's no reason we cannot have this on the March calendar, other than you come back in February and say, March is too soon. That'd be the only reason we don't have it there. So the answer is yes. And that email will allow Ms. Nelson to put a little tickler in to know when she's putting together the March calendar, let's get this case on it. Okay.
Thank you, Judge.
All right, Mr. Abate, anything else on behalf of the state?
Just that I agree with the court. I'm open to the middle ground. The only counter offer I had ever received to the life was 5 years probation to a false statement charge, which is why the state had really, engaged in prior plea negotiations. I'm always open to something less than life or murder. That we can find a middle ground, but false statements is not one of them.
Okay, so right now there's a pretty big gulf, Ms. Brown-Moore, but that's not unnatural for cases like yours where there is a very viable defense. I see murder cases where it's a guilty plea in front of a jury. That's not your case at all. And so maybe there will be something that is in between, or as I gave the example where Mr. Abate says, we're going to recommend X, but because we'll reduce the charge, then Ms. Gordon can recommend something a whole lot less than X, maybe more than 5 years probation. And that might be where we end up. So those opportunities are still out there. And certainly, Ms. Gordon, if something like that presents itself before the trial calendar and you're able to be there, let Ms. Nelson know. We can get it on an earlier calendar.
Sure.
Okay. All right. Thank you, everyone.
Thank you.
Thank you, Judge.
Thank you, Judge.
All right, let us pivot back to Ms. Young's case that just keeps getting more complicated the more I hear about it.
And Judge, I haven't been let into the Zoom yet.
It's not a let-in, it's wide open. So do you want the Zoom information? We don't have a waiting room. If you've got the invitation and type in the meeting ID and passcode, you're in. Because Ms. Clark's computer is in, so yours can join as well. I'm happy to share that.
Judge, do you have the meeting ID?
I do. It's 951-7561-6806.
Oh, and a meeting code, Judge?
Yep, I'm gonna write that down and give it to you, so this stays as our hearing and not the whole world's hearing.
Thank you, Judge.
Go, thank you. You're in. Why are you sharing your screen?
Sorry, wrong thing. Press the wrong button.
That's okay. There we go. Great. Okay. Ms. Jackson, we did not have a plea with Ms. Brown-Moore, so we won't be having any pleas this morning. I appreciate you dialing in and hope you have a great weekend if I don't see you again today.
Good morning. Thank you so much. Have a great one, Young.
You too. And Ms. Tucson, same situation. Ms. Young's case that we're about to hear is just motions. And in the afternoon, we've got Michael Reynolds, and that will only be motions as well. So you are both free to go. And I look forward to seeing you guys next week.
Thank you.
Okay. Bye-bye. All right, Ms. Clark. If you'll call your first witness.
The state calls, Detective Tristan McCullough.
I'm just gonna work, if that's okay.
That's fine. If you want to be even more hidden, you can have the jury room.
Raise your hand. You swear affirm that the testimony you will give the truth, the whole truth, and nothing but the truth, so help you God.
Swear.
You may have a seat.
Detective Tristan, Tristan, McCulloch, McCulloch.
Detective McCulloch, can you slide that, the chair slides, it doesn't roll, a little closer to the microphone. Our court reporter is virtual today. I need to make sure she can hear you. Thank you.
Where are you employed?
I work for the Cobb County Police Department, I'm
Okay.
currently assigned to major crimes.
And what is your position?
I'm a detective with them.
And how long have you been employed with Cobb?
8.5 years.
What was your position around the time frame of October 5th and 6th
I was assigned to the major crimes unit at that time.
What year are we
of
talking about?
2020? Excuse me,
Okay.
October 5th and 6th of 2020.
2020, I was assigned to major crimes.
And what does that mean in Cobb?
It's our crimes against persons unit. So we investigate homicides, robberies, rapes, any crime against a person. And then we also have a separate unit that's specifically crimes against children's.
Okay.
But they're under the major crimes umbrella.
And at that time, were you post-certified?
Yes,
And did you complete any mandatory training during that time?
a lot of training. Yeah, I have over 1,800 hours of training, I believe.
So pursuant to your involvement in this case, the East Point case, did you have an opportunity to speak with the defendant, Raven Young?
Yes, I did.
Do you know when
October 6th, 2020
and where?
at East Point Police Department.
Okay, and do you know what county?
That's Fulton County.
Okay.
Correct.
And in East Point, where was it? Where were you physically located during the interview?
In one of their interview rooms.
But you were in, so you were at East Point PD headquarters or one of their
Yeah,
buildings?
that's correct.
Okay.
Could you tell the court why you were brought in?
So in Cobb, we had a total of 3 robberies that utilized the same suspect vehicle. Detective Jackson was investigating a Church's Chicken robbery and a Family Dollar robbery off of Riverside Drive, I believe. And then on October 5th, I was notified of a robbery at the Burger King up off of Barrett Parkway in Marietta. The suspect had left in a black vehicle. Video from the Burger King showed the suspect running to that vehicle, and then the vehicle was parked in the neighboring business parking lot. I believe it was ADMA, it's a medical facility. And video from ADMA showed the vehicle pull in, the male suspect get out of the driver's seat, walk to the Burger King. While that's occurring, the other occupant of the vehicle doesn't exit the vehicle, but gets over into the driver's seat, kind of adjusts the vehicle. The male suspect runs out of the Burger King and the vehicle takes off.
So the person who the video shows getting out of the black car got out from the driver's seat,
Correct.
and then the other occupant gets in the driver's seat and is
Yeah.
effectively the getaway driver for the person who comes running back from the Burger King.
That's correct.
Okay.
And you referenced the car, the car. Could you talk more about that?
Yeah, so we had images from the surveillance video from both Burger King, Family Dollar, and Church's Chicken. We gave those to another detective, Detective Stannard, and he searched license plate reader systems and camera systems throughout our county and was able to identify the vehicle as the black Kia Rio that is registered to Miss Young's mother.
Okay. And the link with East Point and the Family Dollar in that car, how did you connect those? Or how did,
On the 6th, we got a call from East Point Detective Watts, who stated that, let me back up. We sent out some BOLO information with images of the vehicle and the suspects, asking neighboring jurisdictions to help us identify.
And I missed one thing. The images of the vehicle included a tag number, or it just was a black car?
It was the images were not good enough on the video for us to read the tag number from that. And so we searched the license plate reader systems. We used Flock. And in the time surrounding the robberies and the area surrounding the robberies, we were able to narrow it down to the black Kia Rio.
Got it. So when you were able to put a BOLO out, there might be an image of individuals and car, but it also had the tag number because of the Flock data.
I don't remember if the tag number was on the BOLO or not. I know Detective Jackson sent those out because his robberies were prior, but I believe we updated it after my robbery. Because I know Detective Standard, we didn't identify the vehicle until after my robbery on the 5th.
Okay. But would Detective Watts, who called you or your colleagues, do you know if Detective Watts would have had the tag number so that she could feel pretty comfortable that it's a match?
Yeah,
a lot of
so-
black Kia Rios out there.
Correct. So from the East Point robbery, there was a witness who was able to obtain the tag number and stated that there was a female driver, a female getaway driver, if you would. And that witness was able to provide that to Detective Watts. And so once all the information came together, Detective Watts was able to say, hey, our robberies are related.
Because of the tag number.
I believe that's correct.
Okay. That's all I was
She
trying.
had gotten that prior to us. She
Okay.
had gotten that on the 4th from a witness of the East Point robbery.
Okay.
and so to your knowledge, the date that Watts communicated to you that she became aware of the tag number and the make and model of the car was on the 4th, which is the day of the Family Dollar robbery.
Yeah, East Point's robbery was the 4th. She had the tag number from the witness. The Burger King robbery in Cobb was on the 5th. And we had obtained the tag through license plate reader systems. And then Detective Watts called me on the 6th once she realized that it was all related.
Okay. So Detective Watts already had information suggesting a black Kia Rio license plate 1234 had been involved with a Fulton County armed robbery. As of the 5th, you're able to say on behalf of Cobb, we're interested in a black Kia Rio license plate 1234,
Correct.
and the dots are connected.
Correct.
I didn't realize. So your Burger King robbery actually is after the East Point Family Dollar robbery.
That's correct.
So it falls, the East Point one falls within the start and stop of the Cobb robberies.
Correct. The first two, the Church's Chicken and the Family Dollar down off of Riverside Drive happened at the same day, same time. And then it was East Point and then
Okay.
another Cobb. And then during the interviews with Mr. Furlow, there were other admissions to other robberies as well.
Okay.
So can you describe your circumstances around actually talking with Defendant Young?
Yeah, so once we got the call from Detective Watts stating that they had suspects in custody, we asked if they were still in custody and if we could come down and interview them. Detective Watts stated that they were still at East Point. And so Detective Jackson and myself traveled down to East Point, met with Detective Watts, and she arranged the interview. I believe they were held in the jail there and then brought into the interview rooms, both Young and Furlow. And we interviewed Young and then Furlow.
Okay.
So you interviewed both,
That's correct.
not together.
No, not
Okay.
together, separate rooms.
Yeah.
And the room that you interviewed Defendant Young in, can you describe the room?
It's a typical police interview room. It's a chair for the defendant or suspect to sit in, and then 2 chairs for law enforcement to sit in. It's audio and video recorded. I believe East Point's actually is like old school with the mirror.
And you were in the interview room, the defendant Young, are there other persons in the interview room?
Yes, Detective Jackson interviewed with me.
Okay. And did he participate in the interview?
He did.
Okay. And how?
So as I was the lead detective on the armed robbery at Burger King, so I lead the interview. And then basically the way we do it is if I run out of questions or need to think about a new line of questioning, we kind of signal each other, because as a second in an interview, we're taught you stay quiet while the lead is doing his thing. And so we kind of signal, hey, do you have any follow-up questions? Because he's taking notes, and as I'm asking questions, another question might pop up. So I kind of looked at Jackson and said, hey, do you have any questions? So he asked some questions, and then I asked some more questions, and it kind of went back and forth.
Okay. And was defendant Young physically restrained in any way during your conversation?
Yeah, she was in handcuffs. Or waist, it might have been waist chains. I don't remember.
Okay.
But she was restrained in some way. If she had wanted to demonstrate by moving her hands up, she could not do that.
She could not. I specifically remember when I read Miranda and had her sign the waiver, we had to like help her.
Okay.
Because her hands weren't able to move.
And just for purposes of the record, were you armed?
Yes.
And did you consider the defendant to be in custody at that time?
Yes.
And did you advise defendant Young why you wanted to question her?
I did.
And did you advise her of any rights prior to questioning her?
I did. I asked some administrative questions first to confirm her name and date of birth and her highest level of education, and if she was under the influence of any drugs or alcohol. And then I read her Miranda rights.
Okay. How were the Miranda rights administered? Were they verbal or in writing?
So we have a form, and I should have brought an example. The top part is the administrative questions. It has the case number, your location, the questions I had just referenced, and then we read the rights. You have the right to remain silent, anything, so on and so forth. I'll make sure that she understands, or the defendant understands, and then there is a bottom paragraph that the defendant reads, basically saying, hey, there's been no promises, no threats or coercion, anything like that. And then we ask, hey, do you agree to speak with us? If so, please sign. And she signed the Miranda waiver.
And did the defendant appear to understand each of the Miranda rights as you read them to her?
Yes.
Did she ask any questions about her rights? Did you recall?
I don't recall.
And you did say you asked administrative questions, so you were aware of her age?
Yes.
Okay. And her level of education?
Yes.
And she appeared to understand the English language?
That's correct.
All right. Did she appear to be under the influence of drugs or alcohol?
No.
Did she, from your point of view, did it appear that the defendant was deprived of food, water, or sleep?
No.
Did she agree to give up her right to remain silent and to answer questions without the presence of a lawyer?
She did.
Did you offer her the slightest hope of benefit in order to induce her to answer your questions?
No.
Did you threaten her?
No.
Did the defendant in fact give you any statements?
She did.
Okay. Can you go over those statements or do you?
Top of my head, no.
Okay, all right.
We don't need to, I know, Ms. Clark, this is the first suppression hearing you and I have done together. We don't need to get into the content of it unless it's somehow relevant to the voluntariness of the statement.
Okay.
What was said, and if it's relevant, you can use it at trial. If it's not, you can't. To me, the threshold is cleared when you've covered the parts about the administration of the waiver, whether this was recorded, and if at any point during the conversation that Detective McCullough had with Ms. Young, she said, "I want to stop," and whatever his answers are to that. So you can proceed, but you don't need to get into, did she admit that she was at the Burger King or this or that? That's for a jury or sentencing.
Thank you, Your Honor.
Sure.
So you mentioned that East Point did have a recording.
Yes,
And so the recording was at that time.
yes,
Okay. And did you have an opportunity to review that recording?
I did.
Okay. And were you provided that recording? How did you receive that recording?
Detective Watts sent me the recordings of both Young and Furlow and part of her case file.
Okay. And did you review that recording in its entirety?
I did, yes.
Your Honor, just a moment. Your Honor, if the court will just give me one moment. I'm just trying to bring.
So before you play anything, so this isn't in evidence yet. Is there something you want to get into evidence?
Yes, Your
Okay.
Honor, it does. I just wanted to try to
Have
bring
it
it
teed
up.
up?
Yes.
Okay.
Okay. So, and the video, there's an image that I put on the screen. I've shared my screen. There's a video. Does that video or that image look familiar to you?
Yes, ma'am. It's my interview with Ms. Young.
Okay. And you reviewed that interview prior to this proceeding?
Yeah, I actually watched it in full the morning of October 11th.
Okay. And the recording is the same recording that the state has, correct?
I believe that's correct.
And does this recording fairly and accurately depict what happened that day?
Yes.
And to your knowledge, are there any additions or deletions from that video?
Not to my knowledge, no.
Your Honor, at this time, the state moves to enter this video as State's Exhibit 1.
Okay. And it exists in what format? There's a brown envelope.
Yes.
Okay.
So it's been provided to Defense Counsel prior to, and I have a flash drive that has the one for you and then one for the board of order.
Oh, fantastic. Okay, so this is State's Exhibit 1. This is 2 copies of State's Exhibit 1.
Yes, Your Honor.
All right. Ms. Mignot, any objection to the admission for purposes of this hearing, the suppression hearing of State's Exhibit 1?
No objection for purposes of this hearing.
Okay, State's Exhibit 1 is admitted and you can publish any part of it that you want to. I'm also happy to review it as part of my consideration of the motion to suppress.
Okay, thank you, Your Honor.
You have any idea why we're coming to talk to you? No? Okay. So East Point picked you up yesterday, or Atlanta, I guess? Yeah, they brought you over here because East Point had some stuff, some charges or whatever. So they gave us a call, and I've got a few questions for you, okay? But before we get started, I just want to read you something. I know they've read this to you a couple of times in the past couple of days. They haven't read Miranda to you? No? Okay. You ever watch any crime TV or anything like that? Huh? Well, I'm going to read it because I've got some questions for you, okay? What's your highest level of education? Some college? Okay. Where'd you go to college? What were you studying?
I went to Southern Crescent for pharmacy. Then I went to Gwinnett to be a teacher. Trying to get into college now.
You're not under the intoxication of any drugs or alcohol. And you read and write English. It's your primary language. Okay. Okay. Before we ask
Detective Jackson would be the leg that we see on the screen.
Yes. You have a right to stop alert for advice before we ask you any questions you have him or her with you during questioning. If you cannot afford a lawyer, one will be appointed before any questioning if you wish. If you decide to answer the questions now without a lawyer present, you still have the right to stop answering at any time. You also have the right to stop answering at any time so you can talk to your lawyer. Can you read this paragraph for me, or do you need me to read it to you? Coercion. You will talk to me? Okay. Just sign that form. If you're able. Very much. So basically the reason we got called in here is because of a car. There's a 2020 Kia that you drive. That's that registered to. Your mom, what's her name? Okay. What's your name? What's your Raven? Young. What's your middle name?
So are you going to play the rest of it or?
No, Your Honor, I just wanted to play that part.
Okay.
And I have some follow-up questions. So Detective McCullough, just want to make sure, at any point, I see that the interview lasted 35 minutes. At any point, does the defendant ever invoke her right to remain silent? Right to remain silent. Let me stop sharing my screen. Okay. All right. Okay. Does she ever invoke her right to remain silent?
No, she does not.
Does she ever invoke her right to have a lawyer present while you questioned her during that entire 35 minutes?
She had asked a question about thinking she needs an attorney, but she asked it towards me, and I told her I can't advise her on legal, her legal rights. Or yeah.
Okay.
Was that at the outset or later on in the interview? It was pretty hard to hear
No,
what was going on.
It was during the line of questioning.
Okay, so I'm making the number up, but at minute 15, she may have said, hey, do you think something to the effect of, hey, do you think I need a lawyer? And your response was along the lines of, I can't make that decision for you.
Correct.
Okay.
And even after that point, could you tell, like, after you advised her that you can't advise her on that part, did the defendant continue to speak with you?
She did, yes.
Okay, so she never invoked her right to remain silent.
Correct.
Your Honor, the state has no further questions.
All right. When the interview how did the interview come to a close? She stopped answering questions, or you looked at your watch, or what do you recall about why at 35 minutes it was over?
I believe we just had no more questions. We had gotten what information we needed and thanked her for her time.
Okay. And you don't know what happened to her from there. She wasn't in your custody. She was in East Point custody.
Correct.
Okay.
Yeah, I had not seen her again until October 11th in Cobb.
Okay. And what was she doing in Cobb on October 11th?
We had a Jackson Deno hearing that we never went through with the hearing because she pled.
Okay. Got it. But it would have been in connection with the statement we're talking about.
It would have been
You interviewed her one time.
correct.
Okay. Got it. Thank you. Ms. Mignot, do you have questions for Detective McCullough?
Yes, Your Honor. Thank you so much. Good afternoon, Detective McCullough. How are you?
I'm doing well. How are you?
Great, sir. All right, so as it pertains to your interview of our client, Miss Young, Detective Watts had already interviewed Miss Young prior to your arrival, correct?
I believe she had spoken with her. Yes.
And you've reviewed the recordings of the interview with Detective Watts prior to today.
I have not.
Okay. And Miss Young, when you began your interview with her, there's a portion of the video at the onset where she advised you that she was not Mirandized, correct?
Miss Young?
Correct, Miss Young.
I had asked her if she had been read these before. She said no. I asked her if she had watched any crime TV where they read them, just making sure that she was familiar with Miranda rights.
Okay.
To see if she had heard them before.
But she had advised you that none have been read to her regarding her detention as it pertains to being a suspect in the Fulton County crimes.
She wasn't specific about that.
Okay. And Your Honor, we have a replica of the state's Exhibit 1, and we're just going to go to specific timestamps. We're not going to be playing the entire 35 minutes.
Good.
Thank you.
You should go wherever you think you need to go, other than the whole thing.
Thank you. We won't be doing the whole thing.
Yours is only 9 minutes and 51 seconds. I don't know if it's the same interview.
We have two of them, Judge.
No,
Okay.
Detective Watts.
That's the Watts interview. Okay. So that one's not in evidence yet.
Not it.
Okay. Did you take care of that, Deputy Gordon? Thanks. It's Friday. There we go.
If you tell me, okay.
The other thing we could do, if for whatever reason your version isn't working, is we can work off of Ms. Clark's, I'm sure. Oh, that looks better. Okay.
I don't like how this player does it.
Who was that out there? Was it Hudson? Sounded familiar. He was using his outside voice.
Yes.
Yeah, you can start. All right, you get volume.
So when you shared it, when you do share screen, there's a little box in the, well, you're going to have to unshare screen for a minute. And then when you hit share screen, a little window comes up and there's a box in the corner that says share video audio. If you don't click that, then Ms. Clark will show you.
Here, share sign, and optimize for video clip. And then share. This one right here?
The bottom, yeah, the middle one, where she's sitting.
Right here, okay, and then you share. Perfect, all right.
So they gave us a call. A few questions. Before we get started,
So it won't. There we go.
Well, I'm gonna read it because I've got some questions for you, okay? Brought you over here because he's pointing out some stuff, some charges or whatever. So they gave us a call, and I've got a few questions for you, okay? But before we get started, I just want to read you something. I know they've read this to you a couple times in the past couple days. They haven't read Miranda to you? No? Okay. You ever watch any crime TV or?
Okay. Detective, did you hear Ms. Young say she's never been read Miranda right there when you questioned her?
I do.
Okay. And so statements that she provided to Detective Watts were not Mirandized statements, correct?
That's what I understand from that.
Okay. And when you got contacted by Detective Watts, you came down the same time, correct? Same day?
Yes, same day.
Okay. And when you got there, you had an opportunity to question Ms. Young about what you believe were crimes committed in Cobb County.
Correct.
Now, as it pertains to your questioning, when you started questioning Ms. Young, she advised you that she didn't understand some of the questions that were listed in the document, and you showed it to her, right? You showed her your Miranda document.
I had her read the bottom paragraph of our Miranda waiver. Yes.
Okay. And she also instructed you in that video that there was portions she didn't understand at timestamp 7:35.
I'd like to hear that. I didn't hear that before.
I don't recall that. Because of a car. There's a 2020 Kia Rio that you drive. Yeah, who's that registered to? Your mom? What's her name?
So that's past it because they're talking about the Kia Rio.
Is there any way to turn it up a little bit? I can't hardly.
The court system would have to turn it up because we are not controlling it from our computer.
It comes out, the speaker is at the bottom of the microphone, so lean into that.
Okay.
That's where you'll best hear it.
Yeah, it's a weird system.
It's a great system. You just don't know how to use it.
Thank you very much. So basically the reason we got called down here is because of a car,
Yeah, you gotta move further back.
if you're able to.
I don't mind if you just go a minute before it. We can listen to a minute. It's not that long. Go to 6 minutes. Okay.
Local lawyer for advice before we ask you any questions and have him or her with you during questioning. If you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. If answer the questions now without a lawyer present, you still have the right to stop answering at any time. You also have the right to stop answering at any time until you talk to your lawyer. Can you read this bottom paragraph for me, or do you want me to read it to you?
Did you hear her say she doesn't understand, sir?
No.
Okay.
She's reading the paragraph.
Yeah, she's reading the paragraph, Judge, but before she said she doesn't understand.
Do we have the waiver? Do we have a copy of the waiver?
No, Your Honor.
Oh,
I do.
okay,
I can provide it to the state.
okay. All right. Keep going.
Crank her up again, let me see if you can hear.
This bottom paragraph for me, or do you want me to read it to you? Coercion. You willing to talk to me?
Did she basically read out loud what that paragraph says?
Yes.
Okay.
Verbatim. She struggled on the word coercion, and I.
Plenty of people do.
For her, yes.
Okay.
Now, she expressed to you that she didn't understand, and you still had her sign the waiver anyway, correct?
I never heard her say, I don't understand.
Okay. Now, as it pertains to your investigation, you were looking for a Burger King, a male, black male that was driving a black vehicle as it pertains to a Burger King robbery.
Correct. The black male arrived on scene, got out of the driver's seat, and then another occupant that was in the car switched seats
Okay.
and drove away.
I'm sorry, I didn't mean to cut you off. Go ahead.
And they drove away after the robbery was committed.
Okay. And that description,
Your Honor, it's not relevant to this proceeding. Those questions.
Okay, I'm gonna allow it for now just because this witness is from Cobb. And I'm actually gonna ask a question about whether the East Point armed robbery was discussed at all in your interview, but we'll get there. Keep going.
thank you, Judge. Now, you were not looking for a black female at that time, correct?
I didn't know who the other occupant was.
Okay. And it could have been another male.
Could have been a male, could have been a female.
And in fact, there was another male involved with the line of questioning as it pertains to Miss Young on the exact same date that you came down from Cobb.
There was another male involved in the other two Cobb incidents that we had on video. The second person involved in the Burger King robbery, I couldn't identify if it was male or female.
Okay. And in your line of questioning, the people you questioned on the day you questioned our client was another male, correct?
You're referring to Denzel Furlow?
Yes.
I questioned him same day, yes.
Okay. So at the point where you're questioning Miss Young, you don't have any information that a female has been involved.
Correct.
Now, Detective Watts, you testified that Detective Watts gave you the video footage that is entered into evidence as State's Exhibit 1.
Correct.
And your testimony is that you questioned Miss Young a different day than when she was taken into custody? Or it's the same day?
From what I recall in my report, the East Point robbery was on the 4th. The Burger King robbery in Cobb was on the 5th. Atlanta PD stopped the car later that afternoon, took them into custody, and then I interviewed on the 6th.
Okay. Now, you interviewed Miss Young on the exact same day she was in custody at East Point.
She was in custody when I interviewed her, yes.
And
I don't know the exact day she was taken.
It's the same day that Detective Watts had interviewed Miss Young.
Okay. I don't know that for sure.
Okay. Now, if Miss Young is wearing the exact same outfit at the time you interviewed her, it would be fair to say it's the same day, correct?
Why is that? I mean, if she spent the night at the East if she was wearing that orange shirt when she was arrested, this isn't the right witness to figure out what day she was arrested. That's a Watts thing.
I'll move on, Judge.
Okay.
Let's talk about the robberies. I'm a little bit confused when you testified originally. You're saying that East Point Family Dollar robbery occurred first?
So there were a series of 9 or 11. I'm not sure of the number.
Well, I believe you testified on.
Don't interrupt them.
Can I finish?
Yes, you
There were
can.
9 or 11 robberies throughout the metro Atlanta area. 3 of those robberies occurred in Cobb. 2 of those robberies were down off of Riverside Drive, down in our precinct 2 area, Family Dollar and Church's Chicken. Those occurred prior to East Point's robbery. East Point's robbery occurred on the 4th. Then the Cobb County Burger King robbery occurred on the 5th. And then I interviewed Miss Young and Mr. Furlow on the 6th.
Okay, I'm going to ask my question again. In terms of Family Dollar, Churches, and Burger King that you testified to.
There are 2 Family Dollars.
Two.
Which one are you asking about?
I only heard testimony about one Family Dollar.
Cobb County, Family Dollar, Churches, Burger King. East Point, Family Dollar. 2 different Family Dollars.
Okay.
He's talking about 4. And now all of a sudden he's talking about 11. But
The numbers are getting higher.
Yeah.
That's why I want to make sure I'm clear.
But the 4 we've been talking about in Cobb County, Churches, Family Dollar, and Burger King. East Point is also a Family Dollar. And as I understand the testimony, the East Point Family Dollar was before the Cobb Burger King, but after the Cobb Family Dollar and Cobb Churches.
Okay, so we have a Family Dollar in Fulton County on October the 4th.
Correct.
All right, and then we have a Church's Family Dollar and a Burger King on October the 5th.
No. We have a Church's Chicken and a Family Dollar in Cobb prior to the 4th. I don't remember the date. I can find that out for you. Okay,
Okay.
I have the case numbers. Those were investigated by Detective Jackson. Then on the 4th in East Point, there was a Family Dollar robbery investigated by Detective Watts. Then on the 5th of October, Burger King robbery in Cobb investigated by me. And then
An arrest either on the 5th or the 6th when the car stopped.
Correct.
By APD.
correct.
And ultimately, Ms. Young and Mr. Furlow end up at East Point on the 6th for sure, because you're there on the 6th. May have been on the 5th. Watts needs to tell us that.
That's correct.
All right, so as it pertains to our client and your interrogation, you're questioning her about 11 robberies?
No, I am only interested in the Burger King robbery.
Okay,
Detective Jackson was interested in the Family Dollar and Church's Chicken from Cobb, and that's why I brought him along. That didn't really come up, I don't believe, in Miss Young's interview, but it definitely did in Mr. Furlow's interview.
okay. And in this interview, you mentioned to Ms. Young about the Fulton County robbery, correct? You spoke to her about the Fulton County
I mean,
robbery.
she was picked up on some charges out of Fulton County. That's why she was being housed at East Point. So yes, that's how I kind of started the interview.
Okay, but I just want the record to be clear. You questioned her about the Fulton County robberies too. And her involvement or non-involvement.
I don't recall that.
Okay,
I know we didn't listen to the whole thing, but what I'm hearing you say is the focus of your questioning would have been Burger King.
Correct.
If Detective Jackson asked anything, it would have been Churches and Cobb Family Dollar.
Correct.
References to Fulton Family Dollar would have been more context and setting. You're here because you were arrested in connection with the Fulton Family Dollar.
That's correct.
But that's not something you drilled down into. Were you the driver? Were you in the backseat?
No,
Why
that-
was your mom's car there?
That was Detective Watson's investigation, not mine.
okay. So those are the questions Detective Watts would have asked.
Yes.
Okay, no problem. All right, as it pertains to the restraints, you can see in the photograph, she was handcuffed,
Yes.
not free to go.
Handcuffed or waist chained, I'm not sure, but yes, she was in custody.
Okay. Now, you testified on direct examination about Ms. Young asking for a lawyer. She asked you if she could have a lawyer, right?
I don't remember her exact question, but I believe it was something to, do you think I need a lawyer?
Go to 16, just so we can start. Sure, 14. Okay.
14.
But usually, if he has to go make a run or something, he'll drop me off at his apartment.
We're looking at 3 armed robberies in Cobb related to your vehicle. 3. Okay. We're not talking about Fulton County where it's a slap on the wrist. We're talking Cobb where it's serious time. Okay.
What did you say about Fulton County?
Sorry, you're
Come on.
I know that there's 1 male at my Burger King. There's 2 males at 2 other locations. So you only hang out with Denzel and Debo?
Yeah, that's the only other person that I know he would ride around with, that I was like, okay, he can be in the car without me being in the car and stuff like that. That's the only other person I know.
What time did he pick you up from the hotel yesterday?
I know it was after checkup because I was mad that he was late picking me.
Okay. That Motel 6 has cameras, so I'm gonna go verify all this. Okay, so shoot straight with me. It was after 11, after 12, before 11.
And I can call a lawyer if I need one.
I can't give you,
Did you hear her ask you, I can call a lawyer?
I couldn't hear.
Okay.
Was it, I stopped listening because it wasn't about that. Did we just get to that? If we
We did.
can rewind just a little bit, I'll listen again, but it was a talk about all the robberies in Cobb.
Do 15.
And I can call a lawyer if I need one.
I can't give you advice on that, that's up to you.
Did you hear her ask you, I can call a lawyer?
Believe I heard, I think I need a lawyer.
Okay. She was asking you if she can call a lawyer, right?
That's not what I heard, but I couldn't hear it very clearly.
Okay. Your Honor, due to the audio difficulties, we're going to respectfully request that the court listen to at least the timestamp 1549 through 1555 prior to making its ruling.
Sure, I'll do that. I think when I put this in my computer and crank it up, assuming it plays on my computer, I'll hear it better. And I'll work through whether it was an equivocal assertion or a question about it versus an assertion. I certainly heard what the detective said, which is, I can't advise you on that, which says to me, but I need to hear it, that it was, what do you think about, or should I? In other words, an inquiry to the detective. And he said, that's not my call, but I will definitely do that. I'll basically do 1530 through 1615. So we bookend it.
Thank you, Judge. And we would also ask the court to pay close attention to the timestamp of the beginning of the footage,
The waiver part.
the waiver part, where our client advised Detective McCullough that she had not been Mirandized when she was questioned by, in her interrogation with Detective.
So we're clear, what I have heard so far is that she said she had not yet been Mirandized. Not that she said, hey, when I talked to Watts, she didn't Mirandize.
No, Judge,
What
it
she's-
wasn't, it wasn't that clear.
Yeah.
But she is speaking about not being Mirandized, and we submit to the court that she wasn't, based on the detective's interrogation video, which is Detective Watts's video.
Okay.
Now, as it pertains to your direct examination testimony, you testified that there was a hearing scheduled on October the 11th of 2023, just a few days ago, correct?
Correct.
And you were present in court.
I was.
And Detective Watts, who is not here today in the Fulton County case, was also present in Cobb County, right?
She was.
This was, I'm sorry to interrupt, October 11th of this year or way back in 2020?
This year,
Okay.
just a few weeks ago.
And may I proceed, Judge?
Yes.
Okay. And Detective Watts participated heavily in the Cobb County case, correct?
In the hearing on the 11th?
Yes.
No.
Okay. And she provided, I believe, your testimony, the video footage in State's Exhibit 1 for you to review. I think you testified earlier that you reviewed it on that date.
I reviewed the video on the 11th, yes, to refresh myself for the Jackson Deno hearing in Cobb.
Okay.
Which didn't happen because ultimately Ms. Young entered a plea in Cobb.
Correct.
Okay. I didn't realize that was just a few weeks ago. Now it's all fitting in with what Ms. Mignon was saying. Okay.
Thank you, Judge. And as it pertains to your, in fact, Ms. Young asked you again in the video for, I don't have a lawyer. She asked you twice about a lawyer, correct?
I don't recall.
18, 20. No, that's fine. 18 is.
There's cameras in the lobby, and there's cameras outside the parking lot. So we're gonna see if the two of y'all get in that car together before it goes up to Burger King and does the robbery. Or we're gonna see if you're in there waiting for him to come pick you up. Did you go with him to Burger King?
Before I answer, I got a question. Because I don't have a lawyer present with you guys. So I'm going to answer the question honestly and truthfully. So what happens after I answer the question?
Did you ever ask about a lawyer, sir?
She stated, even though I don't have a lawyer present, I'm
Okay.
going to be honest with you.
And you never responded to that, correct? You just started asking your next question.
Yeah.
Okay. Your Honor, once again, we ask the court to listen to timestamp 18, at least 20 to 30. Now, as it pertains to the October 11th Jackson Deno hearing in Cobb County, isn't it true that Detective Watts advised both you?
It's not relevant.
Why are we getting into the October 11th Cobb County proceeding and maybe hearsay from Detective Watts?
Your Honor, the issue we have.
The big issue is we don't have Detective Watts, which we're going to need to do.
That's our big issue, Judge.
Okay.
And we have suspicions as to why we don't have Detective Watts, because we know that.
One reason is you didn't subpoena her.
That's number one.
Okay.
That's number one. Number two is she is in a video interrogation room, the exact same one you're looking at now, interrogating our client and getting information. And then she was not Mirandized at all during that entire.
Well, I don't want you to testify about what you think. It's not in evidence. I don't know what Watts did or didn't. We'll need to work through that.
Okay. Now, Your Honor,
The relevance of getting into a Cobb County proceeding.
Well, the relevance was because Detective Watts, who was not present here in her own Fulton County proceedings, was instrumental in shutting down plea negotiations in Cobb County on October the 11th, 2023.
Okay, well,
So-
that's way outside my scope. I don't know what she did with plea negotiations. Our focus here is This particular statement, was it lawfully obtained? And I'll just, my initial reaction in a vacuum, it sure seems like it. I'm going to need to listen to those little segments, but it sounds like so far, Ms. Young was nervous and queried, should I have a lawyer? And the detectives did textbook approved by appellate courts. Hey, I can't advise you on that. So she continued to speak. The missing piece is what happened before, and the case is Siebert, Seibert. That is the U.S. Supreme Court case that Georgia has adopted through the case of Pye, P-Y-E, that says you can't do a two-step where you have an initial interview where you don't Mirandize, you really like what you hear, and then you say, all right, let's make this one official, hit the record button, Mirandize you, and say, hey, those things you said before, now that we're friends, just tell me again. I don't know that that's going to fit quite here, because I also don't think when I listen to the rest of the Cobb interview, I'm going to hear much about Fulton. And so what we may learn, I don't know, and we're going to need to hear from Detective Watts, is that Watts will say, yeah, I didn't Mirandize, query, why? Don't know. That may be a tainted interview, but if what Watts asked about was Fulton Family Dollar, up, down, left, right, and all around, state can't use that. I don't know that it's going to fall in the Siebert/Pye framework, because those cases say Watts interviews without Mirandizing Ms. Young. Tell me all about Family Dollar. All right, see, we're friends. That didn't hurt. Turns the camera on. Tell me all about Family Dollar. It's the same interview twice. I don't know. We'll have to see. But this interview, again, I don't know how it's relevant to this case, but I don't know that they plowed the same ground. And I suspect we'll find case law that says if they didn't plow the same ground, it's not a Siebert violation.
Got it.
But it's already messy for all the reasons that you've identified. So I don't want us to indirectly get into what Watts did or didn't do. We'll need to get Watts here, which will be part 2 of the hearing. And that's not me foreclosing any further examination by you of Detective McCulloch. It just, the back door isn't going to work. We'll need to have Detective Watts here to talk about this case, and not why did you sabotage plea negotiations in Cobb? You have a big axe to swing up in Cobb maybe about that. There aren't plea negotiations right here in the one Fulton case. And like I said, Watts may have dropped the ball by not Mirandizing. We may learn that, lo and behold, it's not on the video. She Mirandized outside the video. I don't know why you do that, but we don't know. So I just want to give you my initial thinking about all this, so you didn't spend too much on stuff that may be fertile for withdrawing a plea in Cobb, but not so much here.
Got it. Understood, Judge. Based on the court's instructions, I have no further questions for this witness, because any further questions that I would have and any exhibits I would be tendering would be the interrogation video with Officer Watts, which this witness has already testified he has not reviewed at all.
Or he may have seen it, but he can't really lay the foundation for it. In the same way you've watched it, he's watched it.
Correct.
Okay.
Thank you, Judge.
You're welcome. So Detective McCulloch, I'm not putting words in your mouth at all, but my sense is from what we've seen and heard from your interview with Ms. Young, that your focus was, tell me about the Burger King situation. And because Jackson was there, what's going on in Cobb with your mom's car?
Correct.
Okay.
And we did ask about a Lilburn case involving a car from a couple of years prior where there was a shooting, just trying to.
That same car?
Yes.
Huh, popular car. But you, in the little snippets we heard, you weren't really asking much about the East Point Family Dollar.
Correct.
Okay.
Our focus was on the Cobb robberies.
Okay. Ms. Clark, do you have any redirect for Detective McCulloch?
Your Honor, the questions that I was going to ask was similar to what you just asked, that his questioning dealt primarily with the Cobb offenses.
Okay, great. Then you can step down. Thank you for your time. Appreciate it.
Thank you.
Ms. Clark, couple questions, and then if you've got other witnesses today, we can do that. Otherwise, we're probably going to just have to put a pin in it and take more evidence on a later date. Tell me, if you tendered State's Exhibit 1 at the trial of Ms. Young here in Fulton County, and Ms. Mignot objected to relevance, how does this come in? Because it doesn't sound like a jury would learn anything about your case, which we're going to call the East Point Family Dollar case, because it's not what McCulloch asked about. I guess I may try to answer your question. It may be 404B because you would seek to admit information about the 3 Cobb armed robberies we just heard about, as either it's one crime spree or it is somehow part of a larger plan and scheme. Is that the relevance? Because it doesn't sound, I thought when we got into this, like, oh, it was a different detective who ended up interviewing Ms. Young, but it was going to be all about, were you the getaway driver for the East Point Family Dollar? And why did you have your mom's car? And what was going on there? Now I understand, not his focus. He didn't ask. He did not ask about that.
Right, so remember at the beginning, I stated that the state intends to file a 404B, and we also raised the point that the motion that was originally filed by the defendant
Was generic.
was generic.
Okay.
So for the purposes of strategy, the state intended to file a 404B once we were informed by the ADA from Cobb that the defendant pled guilty.
Okay.
So it became relevant and that we used it at trial. That's how the statements will be relevant.
The interview that seems to be most pertinent to the charges in this case would be the interview between Detective Watts and Ms. Young.
Right.
But we didn't go through that today. Is that because from your review of the record, that was not a Mirandized interview?
For my review of the record, that was not a Mirandized interview, which the state would not have a problem with those statements being excluded.
Okay, not because they're irrelevant. They may be particularly helpful to the state's case, but your sense is that Ms. Young was in custody when Detective Watts asked her about the East Point Family Dollar situation, and Ms. Young was not Mirandized.
Right, and being that the warrants in this case for the armed robbery, based on my review of the documents, the warrant was issued on 10/6. So based on that, we decided to proceed in this way. And on top of the fact that the defendant, Denzel Furlow, has already pled guilty, and he's in his statement, admitted that he knew Raymond Young. So.
Okay. All right. That's helpful from the state side. So Ms. Mignot, do you have other witnesses you were going to call today?
No, Your Honor.
Okay. All right. So Ms. Mignot, I will review the 3 segments you've asked me to. The basic waiver exchange, again, about this question of, did she say, I don't understand, or was that in fact language that she was reading aloud from the waiver? And then 2 instances, one around the 1540 mark and one around the 1830 mark, where Ms. Young asked about representation or said something about representation. So I'll review all that. You've raised the larger issue of, even if all that ends up being, I find that the statement was voluntarily given, there's a larger environment of Detective Watts having spoken with Ms. Young first. And it sounds like it was not a Mirandized statement. So how do you want to move forward? Is the record closed now, or do you want me to keep it open because you'd like to get Detective Watts in here?
Well, Your Honor, based on the state's assertion, we would ask the court to suppress it. It's not a Mirandized statement.
So they're not going to use it. So the only way they could use it would be for us to have a Jackson Deno hearing. When I say it would be your client's statement to Detective Watts. What I am hearing Ms. Clark say on the record is that at this point, the state does not intend to use any statement that Ms. Young gave to Detective Watts. If they change that perspective, then we'd need to have a Jackson Deno hearing on it. So I could determine if it was a statement that was voluntarily provided under the circumstances.
Right, and so I understand, Judge, as it pertains to whether or not this statements provided in the video that the court is going to be ruling on Jackson Daniel on. That's an issue the defense would have to raise at trial as it pertains to relevance and whether or not it could be presented to a jury.
Correct.
That would be separate and apart from the court's ruling. And that's assuming the court rules that the statements were Mirandized and that the statements are okay or
Right.
lawful.
Right.
Then the issue would be another hurdle. When we get to trial, we have to object to the relevance as it pertains to.
Right. And where the horizon becomes clearer is if there is a 404B notice provided, and then we have that hearing, then the McCulloch interview becomes more relevant. Otherwise, it's tangential, and the focus is not this case, it's these other cases. So I would understand the relevance. The concern would be relevance, but also 403, it being unduly prejudicial, unless I'd already made a 404B ruling that it's coming in because of whatever it is we discuss. I was pressing you a little bit just to know, do we need to keep this hearing open so that you can get Detective Watson here, or because the state has affirmed on the record they don't intend to use anything Ms. Young said to Detective Watts, that you're effectively done with Detective Watts for the purposes of suppression, and I can assess the McCulloch statement based on the record we've made and what's contained in the video recording of his interactions with your client?
I agree, Judge. There's no need to waste scarce judicial resources, in my opinion, to call Detective Watts
Okay.
for something the state has already said they're not planning on using.
Okay.
So for purposes of our Jackson Deno, this would conclude it, and we would respectfully request the court grant our motion to suppress as it pertains to the McCulloch interview.
Got it. Thank you. That gives me a sense of how best to proceed. And Ms. Clark, I know you think it should come in for the reasons you've articulated. So I will take that under advisement. I want to see where we are, since this is not. You may.
So I have one thing, because counsel referenced the outstanding discovery.
Oh, right. Of the video.
Surveillance.
Yeah.
Right. So the surveillance footage, 88 people did attempt to get it, was not available. And of course, I, extended my efforts with my investigative team to attempt to get it. And East Point does not have it. We don't know what happened to it, but we don't have it. So I informed counsel that East Point does not have the surveillance footage. However, Your Honor, I want to also point out the fact the surveillance footage is only of the inside, to my understanding, based on my review of the police report, surveillance footage is only of the interior of the Family Dollar. The defendant, Young, in this case, the vehicle was identified based on witness statements that were made, that individuals that saw the car outside.
Okay.
So just wanted to.
I got it. So I fully understand it. It would not be video that law enforcement generated, but it's surveillance cameras in the Family Dollar, outside the Family Dollar, whatever it is. And at some point, East Point says, we got it, and then they lost it. Is this best what you can tell? Or they said, we know it exists, but we never obtained it.
They didn't say that, they just said they don't have it. All we know is based on the report that at some point Detective Watts reviewed the footage.
Okay. And then from both Mr. Peoples' inquiry and investigators working with him, and yours and investigators working with you, East Point now says, well, whether we had it or not, we don't anymore.
Correct.
Okay. Got it. Well, that'll be, I'm sure, food for the jury as well if this ends up going to trial. Let's talk scheduling. Ms. Young's case is along with Mr. Belcher. He's still moving along with this as well. Is on for, it hasn't been, I don't think it's been published yet, our December trial calendar. We've got to work through a 404B notice if one is filed, but that'll need to come soon if there's going to be time for everyone to process that. But it also sounds like there's some moving parts in Cobb. So my thought is to keep this on that trial calendar, but to understand that we may need, because Ms. Young is on bond, if we had to bump it one, that's not leaving her in custody through the holidays. I'd like to get closure on this. I don't know what the status of Mr. Belcher is, and his lawyer's not here right now. But if Ms. Mignot ends up coming on board on the Cobb side, there may be some legal battles being fought there that you might want to have resolved before there's a trial here. Because it's one thing for the state to be able to say, and she pled to these other armed robberies versus she's charged with and it's still in the mix. Okay. Well, I'll get a ruling on this at least so we get closure on Ms. Young's statement to Detective McCulloch. And Ms. Clark, if you could get working on the 404B notice so we can work through that. When will you know, Ms. Mignot, if you're going to be Ms. Young's Cobb attorney?
I was advised today, Judge, we're supposed to be retained.
Okay. Supposed to. What is your sense as to when it would be and it actually worked out versus didn't?
Actually worked out will be before 5 p.m. today.
Oh, okay. That's plenty of time. That'll be before we even are working on 404B.
Oh,
so we'll all be together again at a time when you'd be able to say, I am or I'm not the Cobb lawyer.
Absolutely.
Okay.
Absolutely.
All right. Got it. Ms. Clark, anything else in Ms. Young's case?
Nothing from the second.
Ms. Mignot?
Nothing from the defense, Judge.
So Ms. Young, you're still on bond. You've been on bond for a long time. Make sure you continue to comply with all the conditions of your bond. Let me see if I can even find that bond order. It's a bond order from, it's now 3 years old. You're supposed to stay away from Family Dollar stores. Keep doing that, okay? Go to the Dollar Tree instead.
No dollars.
No dollars. Go Walmart. And that was the main one. You had a curfew from 9 p.m. to 6 a.m. Are you still abiding by that, or you sort of forgot about that?
No, I'm still abiding by it.
Okay, talk with Ms. Mignot about that, and if that is creating a hardship for you, then we ought to talk about modifying that condition. You've come to court every time you need to. You've been on bond, as far as I know, without issue, but I'm happy to be educated on that for now 3 years and 3 weeks, 2 weeks. So I don't know that the curfew is so essential. It sounds like to me, the biggest value of the bond was that you needed to stay away from Mr. Furlow. And we took care of that because he was in custody. Is Debo, I don't want to get anyone admitting anything they don't want to admit. Is Mr. Belcher the same as Debo?
Yes, sir.
Okay, make sure you stay away. He is not in custody, so make sure you and Mr. Belcher stay away from each other. Okay? All right.
Our client doesn't know him, Judge.
I didn't want anyone to admit or deny anything. I just want to make sure she stayed away from him. And that's what we'll do. All right. Then Ms. Clark, when you've got that 404B notice ready, obviously let Ms. Mignot know you'll file it, but reach out to Ms. Nelson so we can figure out a good time to schedule it and make sure we keep this moving.
Yes, sir.
Okay. Thank you, everyone.
May we be excused?
Yes, ma'am.
Thank you. Enjoy your weekend.
And Ms. Clark, thanks for the 2 thumb drives. That's this. I can go put one on Ms. Rivers' desk and not worry about losing mine.
Yes, sir. Thank you.
Ms. Nelson, are we using the same Zoom for our afternoon hearing?
Yes, Judge.
Okay, then I'll leave this on, and Ms. Rivers, we will see you for our 1:30.
See you then.
Okay. All right, you all should be able to hear us now. Ms. Rivers, can you hear us from your location?
Yes, Judge, I can.
Great. We are about to start the Michael Reynolds hearing, but there's someone who's a walk-in. Ms. Clark, I know you're on for this, and Ms. Wood, what's the name of the person? Can you hear us? Great. We are about to start the Michael Reynolds hearing, but there's someone who's a walk-in. That's weird. It's delayed in Ms. Clark's office. Ms. Wood, who are we looking for out here? Is it blank?
Terry and Blank. Judge, can you hear me?
Yeah, I can.
Okay, sorry, I don't know what's going on with my audio, but it's Terry and Blank. I have the case number if you need it.
I'd like it. Is Mr. Blank here?
He should be, Judge.
Ms. Clark's office. Who are we looking for out here? Is it blank?
Terry and Blank.
What's the case number, Ms. Wood?
23 SC 189013.
Mr. Reynolds, you should come up and sit with, are you Mr. Blank?
Come on up.
Why don't you come on up to the podium?
You sit right there. Okay.
All right, Mr. Blank, I'm Judge McBurney. Your lawyer, Ms. Wood, is right there on the screen. And you were supposed to be in court a few days ago for plea and arraignment, but you didn't make it. Tell me what's going on.
Well, I was locked up on the day that I had court. I was just getting out that day.
Okay, where were you locked up?
In the cab.
For something different?
Yes.
When did you get out?
The same day, last Wednesday, the day I was supposed to come to court.
Okay, so court here was on Tuesday, not last Wednesday.
I got out last Wednesday.
Okay, got it. Tell me, we don't have a good address for you. It lists you as someone who's sort of bouncing around. Ms. Wood, have you had a chance to talk with Mr. Blank?
Yes, Judge, I was actually down at the courthouse about an hour ago, so I've got a new address. I will get that filed or to Miss Nelson. I just filed a waiver and I got a good phone number and email address for him.
Okay, so you've waived arraignment for Mr. Blank. You'll get the good address into the system. Where are you living these days?
I currently live in a hotel.
Okay.
Yeah.
Is that the address that you got, Ms. Wood?
Yes, Judge.
Okay. Who lives in the hotel with you?
It's just me.
Just you?
Just me.
How are you paying for the hotel?
I work at Chipotle.
Which Chipotle?
On P Street.
Which one on Peachtree?
I had to pull up the address, but I know it's on P Street. I know the surroundings a little bit though.
What's around it?
You got a Panera Bread right beside it, a bank across the street, and a STK.
Okay. How long you been working there?
Since I got out of since I got out of jail the first time for this Fort County case.
When was that?
In June.
Okay.
But when I just got locked back out for the cab, I started working there again.
What did you get locked up for in DeKalb?
For some marijuana.
Okay. Is that case resolved or you got a bond and you still need to deal with it?
Yeah, I still need to deal with it.
Okay. You, in this case, have a bond. Well, you would have just gotten out, it looks like, in June. Oh, you're one of the Judge Dempsey bonds. You got out on an unsecured bond. You got to stay away from MARTA stations. You doing that?
Mm-hmm.
Okay. All right. So your request, Ms. Wood, is that I lift the failure to appear warrant?
Yes, Judge. And I believe now that I have good contact, hopefully we'll not have this issue again.
Okay. Where's the hotel?
Hotel, it's in Buckhead.
You're staying at a hotel in Buckhead?
Yeah.
Fancy hotel?
Nah.
Four Seasons?
Nah.
Not so much. Okay. All right. Ms. Clark, what do you want to add? Uh-oh, Ms. Clark, not on the call anymore. How about Ms. McCauley? What do you want to add? Any issue with, whose computer is that? With me lifting the bench warrant?
No, Your Honor.
Okay, thank you. All right, so here's the deal, Ms. Blank, you're going to need to stay in touch with Ms. Wood. Do you have good contact information for her?
Yes.
What do you have? And I don't need the number. You have a phone number or
I
email?
have a phone number and her email.
Okay, and does she have your phone number?
Yes.
Do you tend to lose your phones or you've got the same phone?
I keep the same phone.
Do you have family in the Atlanta area?
Yeah, I got an aunt.
Did you give your aunt's number to Ms. Wood?
No, but I will.
Okay, all right, why don't you do that? We will see you next only if Ms. Wood, in looking at the discovery, thinks there are motions that need to be argued. Otherwise, we'll see you when you're either working your case out or you want to go to trial, okay?
Okay.
If you move, which is okay, make sure you tell Ms. Wood, because the burden is on you to keep us posted as to your new address. And you sound a little mobile, so if you go to a different hotel, you find your own spot, make sure Ms. Wood knows that address so she can update it in the system. Next time, it'll probably be different if we can't track you down. We'll just keep you in one place till we can resolve the case, all right?
Okay.
Any questions?
No, sir.
Ms. Wood, anything else?
No, Your Honor, thank you.
Thanks for jumping on.
Your Honor, I'm sorry, I got kicked off for some reason.
That's okay. Ms. McCauley spoke on your behalf and said it's okay to lift the bench warrant. You okay with that, or do you want to overrule Ms. McCauley?
Oh, of course not. I'm not able to. Thank you, Your Honor.
Okay, thank you for dialing in.
All right.
Thank you, Judge.
Bye. Okay, you're good to go. All right, our regularly scheduled event is a motions hearing in State versus Reynolds. That is 18 SC 158000. Mr. Reynolds is here with his lawyer, Mr. Shepard. Mr. Shepard has filed a host of motions that we will hopefully work through today. The state is represented by Ms. McCauley, Mr. Jordan, we're going to tackle these. I want to make sure I understand the landscape. I didn't bring out the piece of paper I was going to bring out. I think I can remember. Mr. Shepard, you have challenged identifications that have been made, and I think if I'm remembering correctly, they were all single photo identifications, but they are made, according to the state, by folks who would know Mr. Reynolds, and so that may end up proving to be a non-controversial means of identification. Number two, you are seeking to suppress statements that Mr. Reynolds made. And that's where I'm going to need that piece of paper, because Ms. McCauley mapped out the various statements and her perspective as to whether they were custodial or not. That's not going to control, but it's a helpful overview as to whether it was custodial or not. And then finally, there is a motion to suppress items that were seized from your client, which I think ends up being only the phone, but the phone was not extracted. So it may be useful because of phone records would show the phone on your person, on your client's person, was in certain locations that are germane to the allegations in the case. Am I missing? I know you have a bunch of motions in limine. We don't need to work through those today, but in terms of substantive evidentiary motions, were there other things you were expecting us to work through today?
Just the only other motion I saw was the state's motion about child hearsay. So I don't know if we're doing that today or not.
We can, if time permits.
It's actually, sorry, it's a residual hearsay motion.
Oh, residual, okay.
Yes, it's residual hearsay motion of statements of the child decedent.
Okay.
My understanding of the motions to suppress.
Judge, Ms. McCauley, please turn your mic on.
Thank you, Ms. Rivers. I'm sorry. Can you hear me now?
Yes, I can. Thank you.
Okay, perfect. So it's my understanding from Mr. Shepard's motions that there's a motion to suppress these cell phone records that were obtained via search warrant.
Right, because you sent search warrants from Uber and to the cell company.
Well, there's two Uber search warrants, one with Detective Smith. The other search warrant was signed by the court. And so the state is going to just submit that into evidence because the court reviewed the affidavit and the application and actually signed the warrant. And by the court, I mean, Your Honor.
Right, no, I saw it.
Yeah.
Would be within.
It was not
investigative run.
included in Mr. Shepherd's motion to suppress.
Okay.
But I did
I
bring
did not
that.
realize there were two separate search warrants for the same information. I think my motion does cover it. It says Uber, the date might be wrong. but-
Well, and we're going to cover it. I mean, I don't want to leave a stone unturned here. This is a case that should have been tried through no one individual's part a bunch of years ago. And so what I don't want to do is we get through today's hearing and then I forgot to rule on something, or I didn't rule on it because it wasn't brought to a head. So we will explore all the search warrants and what flowed from them and what the state's going to use, if anything, and if so, were there issues with the search warrant process. But it sounds like it's a total of 3 search warrants, but to 2 providers of information, a cell provider and then Uber times 2.
Yes.
Okay. And Mr. Shepherd, I think you did receive Ms. McCauley either earlier this week or late last week sent an email that was part of a chain that I started and then you responded to pretty promptly. And Ms. McCauley's answer had a bunch of things attached to it. And I saw the warrant that I had signed that's attached to it. So you should have, I think, everything in connection with the search warrants.
I did receive those on Wednesday of this week.
Okay. So identification, statements, property seized, and search warrant results, and then residual hearsay. All right.
I just looked at it. It is a residual hearsay. I thought it was child hearsay. And I was like, going to argue that child hearsay didn't apply.
Okay.
But
It happens to be a child. It's residual.
I see that now. So
Got it. Okay.
the position has changed substantially.
Okay. Well, we'll get to that. Ms. McCauley, any other motions or topics you were expecting to cover today?
The only thing that I'll bring to the court's attention, and I believe I've also included this in my email, was when we were going through the different motions or statements that were made, the state identified that we would be challenging the admissibility of the CVSA as part of the motion to suppress the statements.
What is CVSA?
It's the lie detector test. It's the stress detection test.
Okay.
That was administered by Detective Smith to 2 different witnesses. Well,
Okay.
the defendant and a witness.
And you were planning on, hold on, why is that? You're saying challenging its admissibility or seeking to demonstrate that it is admissible?
No, seeking to demonstrate that it's not admissible. The
Okay.
CVSA results.
All right.
I tend to agree with that.
Okay. So it may be not a fight. I tend to agree with it as well. But of course would always be open to hearing evidence and argument of law. Where's your email? Here it is.
I said I was going to try to admit that.
So
Okay.
the only reason why I identify it is because it is part of one of the statements.
Yes. So I'm looking at your email now. There was a June 21, 2017 interview of Mr. Reynolds. Ms. McCauley says it's not custodial, but whether it is or not, if it's coming in, if I deem it is admissible, the state does not want the CVSA information to come in. So
Now I'm thinking, I'm trying to suppress the whole thing, but if we're going to let some of it in, just the part that helps the state, if there's stuff in there that helps the defense and under the rule of completeness, it seems like I would get my stuff in too. You can't cherry pick a statement and only bring in the stuff that helps the state and exclude the stuff that helps the defense.
sometimes that's true, but you know well that it could be that a statement is entirely admissible, as in it was constitutionally obtained. And partway through, the detective said, well, of course, you've raped someone before. True fact,
That's not helpful.
but that doesn't come in. The state might want, I got it, but it doesn't come in. Even though it would make it all complete, it doesn't come in. And so if the CVSA information isn't reliable or this or that, there may be reasons that would trump the rule of completeness. And so I just read this to be Ms. McCauley saying, we think the statement comes in, i.e. it was non-custodial, it was voluntarily obtained, but there is a subject that's discussed that ought not to come in. But we'll get to it. I appreciate that twist on that statement. Okay. And there were somehow two statements given on the 20th of December. Because you called it 1 and 2.
There are 2 files, so I wanted to identify the files for
Okay.
Mr. Shepherd while he was going through his discovery, because that's how the state identifies it. There is a 12/20/2017. There's 2 files that relate to the defendant being in custody where he actually doesn't make a statement to law enforcement. He invokes after making a phone call to his mother. The phone call, however, is prior to the invocation. It's also made in the police interview room. So the state would want to address the admissibility of that phone call.
Okay. But he's in custody.
He's in custody at
There's
that
a different dynamic. He's not being questioned by anyone. It just happens to be recorded.
Correct.
But for whatever reason, it's 2 digital files.
Yes.
All right. Got it. Let's get going. If you have witnesses who need to be called in a certain order because of schedules or whatnot, you can call them in whatever order you want. Otherwise, tell me which issue, identification or statements or property you want to address through witness testimony first.
Well, Judge, I think I will start with, there's one primary witness for all of it. He's here. He's available. I do have a second witness regarding the second search warrant for the Uber records. But I think it makes the most sense to start with the motion to suppress ID, and then it kind of all flows through the various topics that we've outlined for today to the motion to suppress, and then we can go into the motion to suppress the Jackson Deno, all with the same witness. I think there's a way to do it very, very succinctly that will not involve a lot of stopping and starting, unless the court wants to do it issue by issue.
No, ma'am. I'll be able to flow, especially if you, through the witness, say, let's shift to the statements you obtained from Mr. Reynolds or whatnot.
Okay.
And then we'll give Mr. Shepherd a chance to cross-examine that person. And there may be some things we need to talk through in terms of argument, or I want to submit the search warrant, tender it that way. We can handle it however you want.
Okay.
So if I could just, so my cross-examinations will be more limited. If we could just briefly talk about what needs to be addressed specifically with regard to my motion to suppress evidence. Paragraph A of the evidence to be suppressed, for instance, references search incident to arrest. And if there's no evidence the state intends to introduce into trial that was recovered from my client's person at the time of his arrest, then that would be moot. And
Right.
I don't know what they have or what they intend to use.
No, fair question. So let's clear. I thought that was the phone.
So their phone was seized and it was placed into evidence. The phone was never extracted, but it was placed into evidence. It's not operable. It had a code on it and it could not be extracted because there was a code on it.
Right.
I think that the state would elicit testimony that there was a phone recovered, but they couldn't get a search warrant for it because it would have not have made any sense.
So you don't know that the phone that was recovered is the phone with phone number 1234 that relates to the cell records.
I don't know the contents of what is in the phone. The cell phone records and the search warrant for the cell phone records was based off of information that the detective gained through other interviews.
Sure. I'm not asking what's in the phone,
Right.
but sometimes people can take apart the phone and say, well, because of the IMEI, we know that this phone had phone number 1234. It's a brick as far as you're concerned. Other than the fact that Mr. Reynolds had a phone on him, there's zero for the state evidentiary value.
Correct.
So the answer to Mr. Shepherd's question of what, if anything, taken from Mr. Reynolds at the time of his arrest does the state intend to use? The answer is nothing.
Right.
Okay.
So that-
Moot.
That kind of knocks out A and D.
Okay.
If you look at D, it's the contents of the brick.
Yep.
That knocks out 2 of those. So we just got the Uber records and the subscriber information, tower records, et cetera,
Okay.
which is B and C.
Yep. And then we've got statements, we've got identification, and then residual hearsay when we get to that.
Okay, we're going to concede that the statements on 617 and 717 were not custodial, and as well as the 621 being not custodial, because I know he was not arrested till December 20. So
Okay.
we're going to concede that. They can still put up a witness to say he wasn't under arrest, but he wasn't. We would like some time to actually brief the CBSA, and maybe we could address that as a motion in limine.
That's fine, Judge.
Okay. Let me write all this down. We're making progress here.
So the only statements that I'm going to argue about today, if I can, other than the CVSA issue, which will be another day, is the 2 on 12/20.
Okay.
Those are the custodial ones.
Okay. And do you agree that it's actually, there wasn't a statement that Mr. Reynolds made to law enforcement? There were things he said while in custody. It sounds like they were to his mother over a phone, or you think there's actually a time when a detective came in and said, "Hey, tell me what you did here."
Well, my understanding is the second statement is his invocation of the right to remain silent.
Right.
Which shouldn't come in.
Right. I agree.
Well, yeah, that's what the state.
Yeah. So what the state's trying to get in is your client's conversation with his mother over a phone that preceded, allegedly, Mr. Reynolds's invocation of his rights.
Yes, I would still be trying to suppress that because he was in custody.
Okay, got it. So we do need to hear some evidence about that and receive argument. We will table for today the CVSA issue.
Okay, so basically the defense has agreed the state is allowed to use 617, 717, and 621, and we'll have to argue later about whether the CVSA is excluded for some other reasons the state wishes to assert. We've excluded the cell phone that's a brick. And as far as identifications, the state can put up a proffer about the basis for the single photo IDs, and they don't have to call the actual human beings who did the single photo IDs. I think their detective could probably
You can.
testify to that.
Sure. And if at trial, I mean, it would have to be shored up at trial anyway, where someone would say, "It's my uncle, and I spent every weekend with him for 10 years.
We're not waiving the live human testimony at trial, but
Sure.
for purposes of today and to establish the basis for the single photo, we're going to just let their police officer testify as to why they did a single photo. And I think
Okay.
that narrows it as much as I can narrow it.
Just to perfect the record, in my email, I said 7/17 as an interview date. It's 6/17 phone call, 6/17 interview.
And then a 621 interview.
Correct.
Got it.
Yeah.
I was going to ask about that because you seem to be listing it in chronological order. I thought it might be. So on June 17th, phone call, non-custodial,
Mhm.
interview, non-custodial. Fast forward 4 days, another interview. This is where the CVSA comes up.
Correct.
So 2 interviews, 1 phone call in June of 2017. The defense is conceding those were non-custodial. It's all 1 month, not 2 months. We just need testimony that the statements actually happened. And then we'll explore in much more detail the December 2017 statement.
That's right. And I apologize. I had the right dates in my motion. I was referencing Ms. McCauley's.
I just had a little error in my email.
It's all good. We're on the same page.
Thank you for letting me kind of squeeze the issue.
No, thank you for squeezing the issues down. This is why I like to have instead of saying, call your first witness, just make sure we understand where we are. All right. So it sounds like, Ms. McCauley, you've got a witness who can walk us through all this, and you think it'll probably start with the ID. We can go in whatever order you want. If I get confused, I'll ask the witness questions.
Great. Thank you, Judge.
This witness is something.
Your Honor, the state's going to call Investigator Darren Smith.
Well, my understanding is these people did know you. You were sleeping with the mom. Okay, she probably knows you then.
What happened to you?
Nobody
Paper
would have
cut?
sex with somebody.
Oh, right on the corner. Ouch.
Sometimes. Yeah.
You said if he said something, what you want me to tell?
Well, it was just, something that matters.
Okay.
By the way, I know we don't want the state's witnesses to know my questions till the jury's in the room. So if I'm not asking questions, it's because I don't want him to hear my questions today. And then when the jury trial starts, he's ready for them.
Good afternoon.
Darren Smith, DARRINSMITH.
Good afternoon, Detective Smith.
Afternoon.
Detective Smith, how are you currently employed?
Well, I'm currently employed with the City of Atlanta Police Department.
And in what is your current role with the City of Atlanta?
I'm currently assigned to our Office of Professional Standards in our Internal Affairs Unit.
And prior to being in the Office of Professional Standards and Internal Affairs, what unit were you assigned to?
I spent previous 7.5 years before that in the homicide unit within the Atlanta Police Department.
And when did that 7.5 years begin?
April, I think, of 2012.
Were you assigned that capacity in June of 2017?
Yes, I was.
Was there a case that you became assigned to in June of 2017 that brings you into court here today?
Yes.
Which case is that?
I had a infant death involving Mackenzie Duffy.
And were you the responding officer, the lead investigator? Tell me about your assignment on that case.
I was the lead investigator on that. I don't believe I was one of the original ones that responded to the apartment in which it occurred, because originally we weren't sure what the cause and manner of death may have been until an autopsy was complete a day or two after the event. And once that autopsy came back and determined that it was, I believe, ruled as a homicide, then that is when I was assigned the case.
And so when you were assigned the case, what was kind of your orientation to it? How did you start investigating it?
The first thing I want to do is obviously talk to the parent, any parents involved, go back to the location where the incident occurred, have a look around, see what's going on, meet with the medical examiner who conducted the autopsy to get information that may be pertinent to my case at a later time, try to identify anybody that was in the apartment when the incident occurred.
When you say infant, what was the age of Miss Duffy when she died?
I believe 18 months, around that. Maybe infant's a bad choice. A small child, I'm not sure what the month time would be on that.
Okay.
But yeah, 18 months.
Let me ask you a clarifying question. When law enforcement is investigating child deaths, do you commonly refer to infants as any child under the age of 24 months?
I would, yes.
I wasn't critiquing. I just was curious. It wasn't a 1-week-old. It was an 18-month-old.
That is correct.
Okay.
Detective Smith, you said that you were part of your investigation, orienting yourself to that investigation, was to determine the other adults that were in the apartment. Were you able to do that in this case?
Yes, I was.
Who did you identify as the other adults that were in the apartment or around the child around the time of her death?
Carissa Denson, I believe, was one adult. There was I think there was another one. I don't remember the name off the top of my head.
Okay. Did you also identify the child's mother?
Yes, I did.
Was there anyone else of interest that came up during your investigation?
Michael Reynolds was one.
And who did you understand Michael Reynolds to be?
The boyfriend of the mother of the infant.
And did you have an opportunity to speak with the various adults or non-adults about their whereabouts that particular day?
Yes.
Okay. And what did you learn from Miss Denson?
She was in one of the bedrooms that morning with the child of her own, and the mother of the infant was there in the morning along with Michael Reynolds. He had given her a ride to her work, which was a short ride up the road, and then returned later. Her son, who goes by Q, was also in the apartment, obviously along with the infant.
And did you also have an opportunity to speak with Mr. Reynolds about his whereabouts?
Yes, I did.
And what did you learn from that interview?
He indicated that he spent the night in the apartment where the incident occurred, got up early in the morning to give Miss Duffy a ride to her workplace, returned a short time later, and then left the apartment and said he went to work, which was, I believe, down at McDonald's down by the airport off Virginia Avenue. And then got a call a short time later that the infant wasn't breathing. And then from there, he drove back to the apartment and then eventually, I believe, ended up at the hospital.
Did you learn anything about the defendant's whereabouts? He said he went to work and then was driving around. Did he give you any indication as to why he would have been driving around?
He was doing some Uber driving in the morning.
Did you take any steps to verify the whereabouts of these adults in your investigation?
Yes, we had an opportunity to obtain some cell phone records of the two adult individuals that were there just to verify whereabouts, which is not uncommon in any type of criminal investigation.
And how did you learn of their phone numbers?
They were given to me by each individual.
And you said that you obtained a search warrant for their records. Did you obtain a search warrant for Michael Reynolds' records?
Yes.
Did you seek a search warrant for all of his records for the entirety of the time he had ever had the phone, or was there a specific time frame?
There was a specific time frame. I believe it was maybe a day or two before the incident, and at least up to the day, if not a little more beyond that, in the day of the incident.
Why would it have been important to know to have his records for beyond the date of the incident?
Just to see what his travel habits were, where he may have gone, who he may have contacted, who he may have spoken to. I've had some experience before where people will have conversations with people about what occurred, and then we may follow up with that lead depending on the information we receive.
But you're getting the type of records you were obtaining, detective, were phone numbers and location, not content. So you didn't get the substance of a phone call, just that Mr. Reynolds called John Smith. And so you might go interview John Smith. Hey, what'd you guys talk about?
That is correct.
2 hours after baby Duffy was dead.
Yes.
Okay.
And did you draft an application and provide an affidavit for that search warrant?
Yes.
I'm going to show you what's been marked, and I'm going to show it to defense counsel. It states Exhibit 3. Show you this one too while we're.
All this the other day.
May I approach, Your Honor?
Yes, both of you have permission to approach witnesses. This is states 3.
This is State's Exhibit.
Okay.
Detective Smith, if you could take a look at State's Exhibit S3 and let me know if you recognize it.
Yes, I do.
And what do you recognize State's Exhibit S3 to be?
This is an application, affidavit and application for a court order for Metro PCS cell phone number.
Is that the affidavit and application that you submitted for the Metro PCS records for Michael Reynolds?
Yes.
Does it appear to be a true and accurate copy of that affidavit and application?
Yes, it does.
At this time, Your Honor, the state would offer S3 into evidence.
Any objection to states 3 being admitted in this hearing?
Not for the purpose of this hearing, Your Honor.
Admitted.
Thank you. Detective Smith, was that when you applied for that warrant, in your probable cause section, did you include every fact and detail that you knew about the investigation at that time?
Yes,
Did you also provide oral testimony when you applied for that search warrant?
I did.
And what was that probable cause that you provided to obtain that search warrant?
Most of it was obviously the initial response to the police and the detectives in there, and then the ultimate outcome of the autopsy report, obviously, that the individual had died, and they had ruled it as the trauma that was there, and that I was able to identify one of the last known adults that was in the apartment for that time frame in the specific times that he had left in the morning. And then also during subsequent interviews with Mr. Reynolds on his whereabouts that morning, and up to when he received a phone call from the mother of the infant, returning back to the apartment, the original location. All that detailed information was put in there, and then the exact ruling from the ME's office as to the cause and manner of death, and then the specific reasons why we would want that information.
Right. And then you was that search warrant granted?
Yes.
I'm going to show you what's been marked in terms of defense counsel states SQ. Take a look at that. Finish.
Yes, I'm familiar with this.
What is States S2?
This is actually a signed copy of the application.
And was that signed by a magistrate superior court judge?
Yes, it was.
And that was the search warrant that let you get the cell phone records for the defendant's cell phone. Is that correct?
That's correct.
All right, thank you. At this time, Your Honor, the state would offer State's Exhibit S2 into evidence.
Any objection for this hearing, Mr. Shepherd?
No objection for purpose of this hearing.
Admitted.
Now, in addition to the cell phone records, Detective Smith, did you obtain search warrants for any other records related to Mr. Reynolds?
The Uber records.
Okay. And why did you want the Uber records?
Well, he had said in his interview that he was driving around doing Uber that morning. I was just trying to confirm that that in fact is what he did, where his stops were, if that information was available.
And did you seek a particular time frame for those records?
I believe it was after he left the apartment and before he came back, once he was notified of the incident.
So you said it was after he left the apartment. Did you have other information that gave you an idea of when he was coming and going from the apartment?
I believe other than what he had mentioned to me at work, and then I believe we had at some point had spoken to the manager at the McDonald's, that he had been there at some point. So we're trying to use all these tools that are available to us to try to verify where an individual was with what other information we can get from the sources that he provided during his interview with me.
And did you submit also an application affidavit for that search warrant from Uber?
Yes, I did.
I'm going to show you what's been marked and shown to defense counsel as States S5. Take a look at that. Let me go finish.
Yes, I'm familiar with this.
And what is States S5?
This is a affidavit application for a search warrant for Uber.
And is that the affidavit and application you submitted in order to obtain that search warrant?
Yes, it is.
I'm going to show you what's been marked and shown to defense counsel as States S4. You can take a look at it.
I'm familiar with this.
And what is States S4?
This is a signed search warrant, Fulton County search warrant for the Uber records for Mr. Reynolds.
Perfect. Your Honor, at this time, the state would move to admit States S5 into evidence.
No objection for purpose of this hearing.
Excuse me, 5 or 4 or both?
4 and 5.
4 and 5. They're both admitted in this hearing. And can you,
Digital
you're gonna
copies, yes.
pardon me?
Digital copies.
No, that'll be great. No, I was going to ask, remind me why you had to get a new Uber search warrant. This didn't include everything, or you lost the results, or what? Why did we repeat the Uber process?
Right. So the records that we obtained from Uber from Detective Smith returned that there were no GPS locations that could be provided. And I wanted the district attorney's office to verify that information. And then so we got a subsequent Uber search warrant to verify that information and then also make sure that we were getting the correct information, because the difference between 2017 and 2022, I think is when that warrant was obtained, is significantly different. And there was some indication that there might have been information that we were unable to get at that time.
Just because of different technology or whatnot, but it was an attempt to confirm the response from Uber back in 2017.
Correct. We had learned from another case, another prosecution, that these records might actually be available and might be more thorough than what was provided.
Okay.
So we got that second search warrant.
Got it. Okay.
Okay.
So 4 and 5 are admitted.
Thank you. All right. So Detective Smith, did those search warrants, when the returns were provided, that assist you in the course of your investigation?
Not the Uber one, no.
No. But the cell phone records?
Yes.
Did the cell phone records ultimately confirm the time frame that was given to you by the defendant and other witnesses?
It showed me the data of the cell phone towers in which he was utilizing at certain times and made the call, which didn't quite match up to where he said he was.
Gotcha.
So yes, it sort of did confirm, if that's the word I'm using.
It confirmed the outcome of your interviews. Would that be a fair way to put it?
Yes, it would.
And just remind me, are we going into these single photo identifications?
Sure, whenever you want to pivot to that. Right now, we've been doing the search warrants. I have a question before we do that. The results of the search warrant, you said confirmed that in fact he made a phone call, or it confirmed your thought that he was not where he said he was? What was the investigative impact or value of the Metro PCS information?
There were several phone calls made after he said he left the apartment, left the infant, went to work. There were several phone calls. We were just trying to track the order in where he went. He said he went to work. There was a defined path. I believe it takes the 285 perimeter from around the I-20 area down to around the airport. Virginia Avenue is where the McDonald's was. Several calls were made, and it was utilizing towers along similar to that route, almost within 900 feet of the McDonald's, and then not there a very long time, and then retraces the steps almost back to the apartment once he received a phone call. So just verifying the route that he took from here to there.
Okay.
Which could indicate a time frame for us of how long it would take to travel from point A to point B.
Okay.
And just Detective Smith, from your own experience, when you're dealing with child deaths or really the death of any individual, is a timeline pertinent to your investigation?
Yes, it is.
I'm going to pivot now to some of your other interviews so we can talk about some of the photo IDs that were done in this case. You showed photos of Michael Reynolds to a number of witnesses throughout your investigation. Is that correct?
Yes.
Let's talk about the first interview that you did. I believe that was with a Carlissa Denson. Did you have that opportunity to interview Carlissa?
Yes.
And do you remember approximately when that was?
Can you spell that just for
Ms. Rivers?
Ms. Rivers?
Sure, it's Carlissa. Denson is spelled Denson.
All right.
Do you remember approximately when that was?
It would have been within a couple of days of the incident.
And when you interviewed Miss Denson, was she familiar with who Michael Reynolds was?
Yes.
What was her familiarity with him?
He was the boyfriend of Garrica, the mother of the infant.
Can you spell her first name?
Garrica, I believe. And he had spent a significant amount of time at the apartment, as did Miss Denson. So they had crossed paths. I never actually got a number how many times they crossed paths, but I was under the impression that they were there quite often.
And Detective Smith, just to refresh your recollection, in Miss Denson's interview, I think she said that Garrica, or she learned that Garrica was dating the defendant around January of that year, and he started coming around February. Would that be accurate?
Yes.
And you said that she had recognized him from the apartment. Did Carlissa live in the apartment where this incident took place? Or stay at the apartment?
Stayed significant amount of time. I don't know if live would be accurate, but stayed there quite often.
And when she was in her interview with you, did she indicate that she had significant familiarity with the defendant?
Yes.
And did it appear that she knew who Michael Reynolds was prior to the death of Mackenzie?
Yes.
In those circumstances, in your experience, Detective, would you normally show a person who was incredibly familiar with the suspect a photo lineup, or would you do a single photo ID?
In this particular case, I would have done a photo ID twofold. One, she was fairly familiar with the subject. And two, she wasn't necessarily a witness that I could identify that he did an act to cause anything. So she wouldn't have actually witnessed any type of crime, but it's more of an identification purpose. Is this the person you're talking about when you say Michael or Mike or Michael Reynolds to me, just to verify that we're talking about the same person? So that was the instance in this case.
And did you also show that same photo to another witness, Jemiah?
Yes.
And do you remember approximately how old Jemiah was when you interviewed her?
Not off the top of my head.
Okay, would it be fair to say she was around 14 years old?
Yeah, she was fairly young, but not quite.
How would we spell her first name?
I'm getting to that, Judge. It's Jamiah. Duffy is spelled Duffey. And do you recall when you interviewed her?
I'd have to look at my report to get the exact day, but it wasn't It wasn't that long after in most infant deaths case, we don't prolong any interviews that we do. We do them as quick as we can in a timely fashion. So definitely within a week, I would guess.
Would it be fair to say that was around June 10th?
Yes.
And in that interview, did Jemiah indicate whether or not she knew who Michael Reynolds was?
Yes.
How familiar was she with Mr. Reynolds?
Again, on the similar as Miss Denson is the impression that I got. She was staying in the apartment quite often as well. And obviously Mr. Reynolds was there quite often in the same time frame that she was. So she was very well familiar with him. The impression I got based on the interview.
And I think in her interview, she actually talks about how sometimes Reynolds would wake her up and actually bring Mackenzie to her on several occasions.
That is correct.
And would you say that she was personally familiar with the defendant?
Yes,
And she was familiar to him prior to the death of Mackenzie?
that is correct.
And then lastly, you also showed a photo ID to Garrica, which is G-A-R-I-C-A, Duffy, D-U-F-F-E-Y as well.
Yes.
And what was Garrica's relationship to Michael Reynolds?
They were dating at the time,
And did you interview her one time or more than one time?
multiple times.
And did she indicate she knew who Michael Reynolds was?
Yes.
Did she indicate how long they had been in a relationship?
Since the first part of that year, 2017, so a little over 6 months, if not longer.
And did you use that same technique of showing her the single photo to make sure that who Michael Reynolds was the Michael Reynolds that you were speaking about was the same Michael Reynolds that she knew?
That's correct.
And that was the same technique for Jemiah Duffy as well?
Yes.
I'm going to move to if defendant statements. Is there any, you want to ask any questions?
Nope.
Detective Smith, you had an opportunity to interview Michael Reynolds, is that correct?
Correct.
Okay, so up until December of 2017, the state and defense have already agreed that those statements, for the purpose of this hearing, were non-custodial. Did you have an opportunity in December of 2017 to speak with the defendant?
Yes, I did.
And when was that?
December 20th,
And where did that conversation take place?
public safety headquarters in the 3rd floor, which is where the homicide office is.
And what was the nature of you speaking with him at the public safety headquarters?
He was arrested that day on the charges related to this case.
And was he arrested by you or another agency or other officers?
One of our fugitive detectives within the Atlanta Police Department.
Fugitive because Mr. Reynolds was running, or just because that's who would serve a warrant that arises many months after an investigation has started, or?
By policy, any warrant for a murder or a violent crime gets handled through our fugitive unit. So it was forwarded to them.
When did you get the warrant, swear out the warrants for Mr. Reynolds's arrest?
I believe the day before.
Okay, so this is all close in
This is all
time.
within a day or two.
Fugitive here has the wrong connotation that, oh boy, we were looking for him for months.
No, the warrant, it took us a while to get cell phone records and digest the data to determine if there was probable cause to present to a judge. And once that was done, the arrest was very swift.
Okay.
So when he was brought to public safety headquarters, where was he brought to?
We have on the headquarters that's where our major crimes unit is. There are 2 separate areas. One is what we call witness interview rooms. And then the second area is a suspect in a room, which is secure rooms with controlled access only.
And was he placed into one of those suspect rooms?
Yes, and the doors were ultimately locked from the outside.
And he was he in handcuffs? Did he walk in on his own? Explain that to me.
When he originally came in, Detective Malmstrom was the fugitive detective. It's common practice, they come in with handcuffs once they get into the interview room, depending on the demeanor of the individual, whether the cuffs stay on or come off. Usually during the course of any type of interview I've done, the handcuffs will come off. But the room, they're not free to leave at that point, once they're in those rooms. I didn't have any issues with Mr. Reynolds when he came in.
And did you ask to speak with him at that time?
I did.
And what was his response?
I believe he wanted to talk to his mother. He was provided Miranda though, and then wanted to speak with his mother.
So you said that you provided him Miranda. Did you do that when you were in the room or when you were outside the room?
Inside the room.
And when you say he was provided Miranda, what does that mean?
He was given his rights. He was notified what he was believed under arrest for. And then it was indicated that he did not have to speak with me if he didn't want to without an attorney present, or he could just decline altogether.
And what did he elect to do?
Again, he wanted to speak to his mother to get some advice.
And did you facilitate that?
I did. I gave him my City of Atlanta cell phone to make that call.
And where did this phone call take place?
In the interview room.
Were you there while it happened?
I was not.
But he was in a City of Atlanta Police Department interview room.
Yes, the room is there. It's monitored. It obviously has video and audio.
When you say it, obviously, is there a big old camera there, or it's one of those where it's a clock and little do you know, but at the middle where the hands meet, it's a
I
camera?
believe at that point, when they built the facility, they got rid of the clock and you can't help but see probably about the size of that. I'm guessing.
Okay.
You can't help but see I believe in 2017.
I think I'm going to object on speculation on what my client can see or not see, or whether he noticed it or not.
Well, I'm just asking what one could see. Why don't you describe what is in the room?
We have a live feed that we can log on to the system at the time and actually watch a live feed of like while watching TV.
But the live feed comes from a camera that's about the size of the wipes that you held up?
In the 2017, I believe they had to install new cameras and they were blatantly obvious.
Okay, not saying that Mr. Reynolds necessarily saw them, but they aren't concealed in any way.
I don't believe so.
Okay.
All right. Even if,
I'm going to object on an even if question, just based on speculation.
well, that really wasn't my question. So
I'll let you ask the question and we'll move on.
okay. Did Mr. Reynolds ask if that call was going to be recorded?
I don't believe he did.
Did he ask to be taken to another location?
No,
Did he ask to step outside the room to make that phone call?
I don't believe so.
Did he ask you to leave or you
I just
stepped
left on
out?
my own. He wanted a private conversation with his mother. I wasn't going to interfere with that.
All right. And that you said that phone call was in fact recorded,
Yes.
and the interaction was also recorded between you and the defendant.
Yes.
You and Mr. Reynolds. I'm going to show you what's been marked as State's Exhibit S1. May I approach?
You still may.
Oh, sorry.
It's all right.
Frankly, this is in the courts. Detective Sims, you can take a look at State's Exhibit S1 and let me know if you recognize it.
Yes.
What is State's Exhibit S1?
This is a flash drive, a data storage device with some, I believe this interview was on it and the phone call.
At this time, Your Honor, the state would move to admit State's S1 for the purposes of this hearing.
No objection for purposes of this hearing.
Admitted.
May I publish?
Yep.
We'll see.
Are you playing this for you or for me?
I mean, I was gonna play it for you. We can move to argument and not play it.
I just wanted to see the sequence of it. We don't need to play the whole thing. Because the sequence to which Detective Smith testified was a little different, I thought, than what I heard you proffer. And so I just want to make sure my order reflects the way it actually played out as to when in time Miranda and phone call occurred.
That's fine, Judge. It's gonna take me just a minute because I do have to launch this on March Networks.
Okay. I'm catching up with my notes.
Let me do this to share to Zoom, right?
Yep, and click the little box that says share audio, something to that effect.
Okay. It's going to work.
We'll see.
Screen, share sound.
You know Detective Smith, right? He'll be here shortly. Right here. Get some handcuffs up here. You go shoot. No, I can go get one. You go sit over there. Wait, turn around, get your feet off you first.
Who's that?
Kevin Otts, investigator Otts. We brought him into the, now still in the arrest, I think, Kevin.
Be good. Let me pat you down real quick. I know you probably did already. You got some money in the back of that pocket. Okay.
Was that a knife?
I believe so.
All right, you get there and be with you in a minute, all right?
He called me, I was at work. That bar called.
When who called?
That bar called, I was at work, I cut the flower.
Okay. All right, we'll be right back with you.
All right.
If he sits there for a long time before Smith comes in, you're welcome to fast forward it.
When you just put it like this, there's no ink or nothing on this, I'll let you just read it. So right index and your middle finger. So these two, yeah, push down. Yeah, push down hard. There you go. Hold on, not that hard. Let me see something. See these two. Hold on. These two. Thumb. Left side. These two. Thumb. to your left ring finger. Yes, longer finger, list your left, just that one. Appreciate it, Big Guy.
I didn't mean to inflict this on everyone. I'm happy to view it.
Okay.
If that makes more sense. If it's viewable on my computer, this looks like pretty funky software. No, I think. Can you stop the screen share?
I did. That's fine, Judge.
Okay, it should be, hold on one more. And that one, okay.
Okay, that's fine, Judge. It's also provided in the transcript that was given to defense counsel.
Okay.
Of this actual recording.
Okay, and to be clear, I didn't hear Mr. Shepherd say anything about it. I was just curious about which came first, Miranda or phone call.
That's fine, Judge. Detective Smith, after you spoke with the defendant and he asked you gave him a Miranda rights, and then he asked to make a phone call. You gave him your city cell phone to make the phone call. Did you return to the room after that phone call had been completed?
Yes, I did.
And after that phone call, did the defendant wish to speak with you?
No, we did not.
Did he invoke his Miranda rights at that time?
Yes.
Did you ask him any questions or continue trying to interview him after that point?
No.
All right. And Detective Smith, you ultimately testified previously that you ultimately did obtain arrest warrants for the defendant's arrest. What was the probable cause for the defendant's arrest?
Based on the investigation, we determined he was the last adult that could have inflicted, I believe, that injury based on the report and the interview I had with the medical examiner's office as to their findings. And then after speaking couple of interviews with Mr. Reynolds, his story wasn't consistent with where he was, where he said he was. I interviewed his boss at work. She said he's normally at work and just showed up that day and then left. So, and then along with the cell phone data, we were able to just kind of plot out where he drove when he left the apartment, and pretty much narrowed down his time frame, and believe based on all of that, that he was the only one that could have caused the injuries that caused the death of the infant.
Pass the witness, Your Honor.
Mr. Shepherd.
Good afternoon. I've only got a couple questions. Okay. So on the day of the arrest, is that the same day that we see my client in this interview room?
Yes.
Okay. And that on this day you did recover a cell phone from him?
Yes.
You haven't been able to get anything out of that cell phone?
I did not. I reached out to our detective in our cyber crimes unit and indicated to him that it was locked. He said he couldn't get into it.
Okay.
At
So-
that date.
So it's been a long time since then. Have you heard any information that since 2017, they've been able to open that phone up and download it?
I wouldn't know because I wouldn't be directly involved.
I'm just asking what you know.
I don't know. I don't know if that happened or not.
Okay. All right. And then you did 2 search warrants for the Uber records?
I did one.
Okay, but law enforcement did a second.
I did one. I don't know if,
Okay.
I don't know what level the DA's is, if they're prosecution or law enforcement, but I did my one.
And then you did a search warrant for the tower records for 404-547-0324. I hope I typed that right.
You said 0324, sir?
Yes.
Yes.
Okay. And that is somehow you've tied to my client.
Yes.
Okay. How did you tie that number to my client?
I called him on it.
Oh, that's,
I believe he answered.
oh, that's
And
a
we set
good
up-
way to tie it to
We set up a
somebody.
time for an interview. At
Call
least that's
them
the
on it.
number I used.
Okay. And, okay. All right. So just about this, I'm going to try to follow the state's pattern. About the 6-pack IDs, I heard you say that generally in law enforcement, you will elect to use a single photo ID rather than a 6-pack. I think you gave 2 different reasons for that. What were the 2 reasons you gave?
It depends on the circumstances. If I'm just trying to, if I've identified somebody that may be involved and someone says, I heard that John did this. Well, John is a pretty popular name. In this case, Michael Reynolds is a pretty popular name. I didn't get any indication here that any of these witnesses, people that I talked to actually witnessed what occurred. So I'm just trying to make sure I'm talking to and doing my research on the correct Michael Reynolds in this case.
I think I can. Okay, keep going. No, keep going. I think I'm starting to understand.
Do you have anything else? I mean, I'm not sure what else you'd want me to add.
Okay, so I think you said also if the person has familiarity.
If they knew him, husband, wife, boyfriend, girlfriend, if they've known each other for a significant period of time, and each detective may do things differently. Some may put everybody in a lineup no matter what. And particularly for this purpose only, it was just to make sure that we were all talking about the same person.
I understand. Okay, so I think I'm getting what you're saying, and that is that, and I'm obviously not, I've never been a police officer, so I not have your training. So if the person has some level of familiarity, and this is more of a, let's make sure we have the right guy and not you saw him kill the person, then you would use a single photo. Because you're not actually I saw the harm happen, but I'm just saying that this is who this is.
I can speak to this case. It's over my career. I've probably shown a single photo up a handful of times in, I don't know, hundreds of homicide cases I'm working. In most instances, it is an array of 6 photos. And but each case is unique and different. Everybody knew each other in this instance. I'm just trying to identify for certainty who all these names are that people are throwing out at me.
Okay,
Just
so
I know who I'm talking to.
So with regard to the single photo ID with Carlissa Denson, you went with the single photo because one, she had a level of familiarity with him and that she was not telling you that I saw him beat the baby to death.
Correct.
So she just is saying he was in the house and this is who was in the house.
And that this is Michael, that this is the Michael we're talking about.
Okay, so is that the same thing true for the single photo ID with Jemiah Duffy? That there was some level of familiarity between the two, and she was just telling you this is the person who was in the house. She was not saying, I sat there and watched him take a baseball bat and hit the baby.
Correct.
Okay. And is that also true for Garika Duffy?
Erica?
Erica.
That's correct.
Okay, now.
But that's a little different there. They were dating each other, so he was spending the night there. So I'm sure his familiarity was a little more with her than it was the other two.
Did I hear you testify earlier that the information you received was that my client had taken Garika Duffy to work and then came back?
Correct.
Okay, so Garika Duffy was not actually inside the apartment when the injuries are alleged to have occurred.
That is correct.
Okay. So her idea was just, once again, this is the person with whom I was dating, not this is the person who I saw, stab the person.
Correct.
Okay. I think I understand now. Okay. Okay, so all I have left now is just the one interview or the telephone call with the mom. So we see my client come into the room and he's sitting there. Then at some point you enter the room.
Correct.
And you give him his Miranda rights.
Correct.
Okay. And then he says he wants to talk to his mom.
Correct. I believe that's the order.
Okay. And did you testify on direct that you stepped out of the room since you believed he wanted to have a private conversation with his mom?
Right. I did. I wasn't in the room during that conversation.
Okay. But the reason why you left the room is because your understanding is he didn't want you sitting in there with him.
I would assume so, yes.
Okay. And that you left because you felt he wanted a private conversation with his mom.
Correct.
Okay. Now, did you warn him that everything he said to his mom was going to be recorded by the camera before you left the room?
No.
Did you warn him that anything he said to his mom could and would be used against him?
No.
Okay, but you did leave.
Other than the Miranda, but that was more of talking to me.
Yeah, but you were no longer in the room.
Correct.
And you left the room and left him inside the room all alone. Did you close the door?
I believe so, because it had to have been locked because he was under arrest.
Okay. And was there any other law enforcement officer in the room with him at the time?
No.
Is there a sign on the wall saying you are being recorded? Anything you say can and will be used against you, even if you're in this room all by yourself?
No.
Thank you. Nothing further.
Mr. Reynolds used your phone to call his mother.
Yes, I gave him my phone.
Okay. Ms. McCauley, do you have any redirect for Detective Smith? It's still detective?
Yes.
Okay.
So far.
Just briefly, Your Honor, Detective Smith, when the defendant was taken to the police precinct and brought up to headquarters, did he at any time ask to be taken to another location to have that private phone call?
No.
Thank you. Nothing further.
All right. May Detective Smith step down?
He may.
Yeah, that didn't trigger anything new.
Okay, great.
All right.
Thank you, sir.
Thank you.
Appreciate it.
Good
You
to
can
see you
leave,
again.
same, you can leave all your papers, you can take the exhibits, you can leave there.
Can I ask you a question? Is that a promotion going to wherever you went?
Different type of work. We'll leave it at that.
Okay. Well, I was going to congratulate you, but now I don't know.
It's just a detective is a detective.
So we've got one more search warrant to talk about. If it's being challenged, that would be Uber number 2. And we have the residual hearsay. So I don't know that you need to call a witness for the Uber number 2. There's an affidavit, and so I don't remember if you articulated the basis other than to say, I don't mean this in a pejorative way, generically, there wasn't sufficient probable cause articulated in the affidavit, and I can evaluate that. We don't need to call witnesses there. Was it more than that, that there were willful misrepresentations? So we've got, no.
It's just that on the 4 quarters of the document, there's not sufficient probable cause. The detective, my understanding from the state is that the person who swore out the second word is off today. And
No, she's sitting in the back of the room.
I apologize. I wasn't going to make her show up. If you want to just have her identify the doctor, document and tender it, that's fine.
Okay. I mean,
I was gonna let the state just put it in.
let's do that. I mean, it's something I'm familiar with because I signed it. So if you'll just tender those two items.
Judge, yes, the state will move to admit State's Exhibit S7, which is the affidavit and application for a search warrant, and S6, which is the search warrant, into evidence.
No objection for purpose of this hearing, and like I said, I wasn't gonna make her come all the way down here just to do that.
Okay,
But
great.
she's here. Oh,
Good to see you. So I'll admit 6, the search warrant, Uber number 2, and 7, the affidavit and application for the purposes of this hearing. And I will certainly review them again and assess whether there was sufficient probable cause in the same way that I will for the phone records, search warrant and application, and Uber number 1. Those 2 are Detective Smith products.
I'm just gonna put the player on the USB, Judge, for the statement.
Okay, good.
I mean, we can go to argument.
Oh, okay.
Motion to suppress and then motion.
You've done what we've got.
Yeah, I mean, it's gonna take a minute anyway.
Okay, before we get into argument, unless you want to argue the 4 suppressions and then get to residual hearsay, but that was the last topic.
It's fine, I can go through the residual hearsay, it doesn't necessarily involve this.
It wouldn't involve a witness. Okay, why don't you just make the record for that and then we can talk about what I ought to do.
Okay, certainly, Judge. So the state did file its motion for residual hearsay. Previously, it was filed in August. It is residual hearsay related to the decedent and statements that the decedent made. And by decedent, I mean the child, Mackenzie Duffy, that's spelled Makenzzie, Duffy, Duffey. And specifically, there are a number of statements that the state seeks to elicit from various witnesses. The first being Garrica Duffy and her sister Kiana Duffy. Kiana is spelled Keanna. And it all revolves around this conversation of Mackenzie having a burn on her hand. So Kiana is watching, Kiana and Jane Duffy, Jane, were watching Mackenzie, and Mackenzie had this little burn mark on her hand. And Kiana specifically asked her who did that. And in the presence of Jane and Kiana, Mackenzie said it was Mike. And at the time, she's 18 months old, but she was saying that it was Mike. Garrica, when Kiana reaches out to Garrica and tells Garrica, 1, Mackenzie has a little burn on her hand, but 2, when we asked her about it, she said it was Mike. Garrica approaches Mackenzie, and she actually approaches Mackenzie and says, Mike didn't do that. Q did that, as a way to kind of question her at 18 months old. And she specifically says in her interview, Garrica's interview to Detective Smith, that she intentionally tried to use other people's names. And when Garrica is questioning Mackenzie and she's using other people's names, Mackenzie says, no, Mike. And on another subsequent occasion, Garrica asked her again who did that to her. And again, Mackenzie told her that it was Mike. What is interesting and what the state seeks to elicit, why the state seeks to elicit this testimony, is to illustrate that this child did have some prior difficulties with the defendant, that she was afraid of the defendant and that she was fearful of the defendant. And this prior act had active violence towards this child. While it is a burn mark, is still an act of violence, is still significant and particularly relevant to this case. So as we look to the residual hearsay exception, when we look at whether the statement is offered as an evidence of material fact, if it's more probative, on a point for which is offered than any other evidence for which the proponent can procure through reasonable efforts, and the general rules of evidence and interests of justice will best be served by the admission of statement into evidence. Obviously, if the child was still alive, we would elicit that testimony directly from the child. Unfortunately, that is not the case. That is the reason why we are here. But it certainly goes to the state's theory of the case and other evidence that would be offered in at the trial, that this child had some prior experiences with the defendant that scared her, and that she had a reasonable fear of the defendant, that he had been aggressive and violent towards her on prior occasions. And that testimony would be offered by a number of other witnesses, including the witnesses that the state seeks to elicit this residual hearsay statement from.
I'm not following the argument about Mackenzie being fearful of Michael. Let me explain that. Not that you wouldn't be fearful if in fact he burnt her. That I get. But as I understand the state's case, it's a circumstantial case that Mr. Reynolds was the person who inflicted the injuries that resulted in Mackenzie's death.
Sure.
That there's not an eyewitness to Mr. Shepard's points when he was questioning Detective Smith. No one saw him grabbing Mackenzie or striking Mackenzie or anything like that. So it's circumstantial. Why is it relevant that you contend that Mackenzie was afraid of Mr. Reynolds? Is there some part of your case where a witness is going to say, actually, she died because she hit her head because she was running from Michael because she was scared of Michael?
No, but what the evidence will show is that Mackenzie was afraid of the defendant, that there's some circumstantial evidence that he was cruel or mean towards her on prior occasions. And that when Mackenzie wakes up and realizes that her mom is not there, and that would frequently upset her. She was very, I'm not going to use the word clingy, but she was a Velcro child to her mother, and to her sibling as well, and other family members.
Sibling being Q?
Being Q.
Okay.
Because Jemiah is a cousin, but she was also,
Cousin.
very attached to Jemiah as well. But that when she wakes up and finds out that her mom is not there, that she becomes upset, she begins crying, and that is when the fatal injuries are inflicted.
Okay. What proffer for me the evidence that you would be presenting outside this residual hearsay that Mackenzie was afraid of Mr. Reynolds?
So there's a couple different witnesses that would testify to that. So he would testify to that. He would testify that Reynolds wasn't very nice to her. I believe he says it in his forensic interview that Mackenzie would cry around him quite frequently. There's additional statements from Garrica Duffy that Mackenzie sometimes acted like she was afraid of the defendant, and specifically when, as it relates to this burn incident, when Garrica questions Mackenzie in front of Mike, she won't give an answer like she had given answers before, but she was looking at Mike, she's looking at her mother, and then looks at the ground and won't answer. So there's that evidence. There's evidence from Kiana Duffy, as well as Carlissa Duffy, Carlissa Denson as well, that Mackenzie acted fearful, was uncomfortable around, and did not like the defendant.
And you think that that type of evidence, to include the burn, would come in not just through residual hearsay. I appreciate this is a subset of the larger group of evidence of what you're calling prior difficulties. Yes. Interactions between these same two people in the same household, where much like we would have it's domestic violence, just happens not to be partners, it's a parent and a child. So it's that same rationale that would, in lieu of a 404B analysis, it's prior difficulties between these same parties.
Right, and they're not parent and child, just to be clear. Reynolds is not the father.
True, but it's adult and child, I guess I should say.
Or partial caregiver and child.
Yeah.
Certainly, yes. And obviously the nature and relationship between the parties is incredibly relevant in a criminal trial. The circumstances of the nature of those relationships is incredibly relevant in a criminal trial, to explain conduct, to explain why certain people would be at a certain occasion, why a child would be given to a 14-year-old cousin in the morning when mom went to work, as opposed to staying with mom's paramour. All of those factors, all of that evidence would be relevant.
Okay. I understand. All right. Mr. Shepherd, why don't you, if you want to present any oral argument as to suppressing the IDs, suppressing the phone call to mom. I don't think there's property to suppress. It sounds like with the search warrants, you're resting on the four corners of the documents, the 3 affidavits. So I'll review those. If there are things you want to bring to my attention, you can do that now. And then obviously any argument you've got about residual hearsay. And we can take it in any order you want, but now would be the time if there are things you want to express.
Just the state's making a lot of assumptions about a small burn.
I don't know if it's a big burn or a small burn. It sounds like it was on the hand, so it's limited in size. I don't know if there was.
Said a small burn.
Okay.
She actually said that during her argument. In any event, I think it's in the discovery too, but they're making assumptions that go beyond what we can assume from a small burn on a child, how it happened. There's no evidence, there's no video, nobody saw how the burn happened. So it's unreliable. And also the probative value is substantially outweighed by the prejudicial effect of this testimony, because they're assuming that Mr. Reynolds did it on purpose, that he intentionally somehow tried to set fire to the child, like a Hamas terrorist, without that evidence. So all we know is it's a small burn, and the state's going to blow this up into some sort of domestic abuse, like he's a Hamas terrorist. And that's basically how they're going to paint him during the trial, is that this child was terrified of him and et cetera. She just said it all out there. And the prejudicial effect of that greatly outweighs the probative value. People get burned accidentally all the time, okay? And to assume that it was an intentional burn when the child barely says it was Mike who did it doesn't mean that it was intentional. So they're going to make all kinds of assumptions about this to try to blow it out of proportion. So we're asking you to suppress that evidence because of the prejudicial effect substantially outweighs any probative value. Now, as far as these other documents, the identifications, now that I understand that these witnesses are not saying this is the person who I saw beat the child to death, they're just saying, yeah, that's the guy we call Mike. I understand now why the detective did what he did. I'm not going to withdraw my motions, but I'm not going to belabor the point.
Okay.
We're just going to ask the court to review the documents, and there's not probable cause that he committed a crime. There's just, he was in the house, and that doesn't give you probable cause to search his cell phones where he has a reasonable expectation of privacy. Also, as far as the statement, this is highly problematic because it's a trap. It's an intentional trap. The detective intentionally let's start with the base point. On direct, I didn't even trick him into saying this part. The state tricked him into saying this part. He says on his own during direct that he stepped out of the room because his understanding was that Mr. Reynolds wanted to have a private conversation with his mother. Therein, it doesn't matter whose phone you're using. If you want to have a private conversation with somebody, you have a reasonable expectation in that conversation. So my client has a reasonable expectation of privacy in his conversation with his mom, regardless of whose cell phone he's using. Then the detective, in order to give the air or the appearance of this will be a private telephone conversation, he steps out of the room in order to trick the defendant into thinking that this telephone conversation is not going to be recorded. This conversation is not going to be used against him at trial. And lo and behold, it is. Never warned him, never said, oh, by the way, there's a camera in here. Everything you say is going to be recorded. Everything you say is going to be used against you. Had the detectives told my client that, hey, by the way, it's not going to be private. I might as well sit in here with you. My client would never have made the phone call or made whatever statements it is that he made. So in essence, this is a clear violation of my client's constitutional rights. It violates the due process clause, et cetera, that you lay a trap of this nature where you give the appearance of a private telephone call when all the while you know that you're going to be recording it and using it against them. For those reasons, we're asking the court to suppress that statement. Also, I think the state's going to concede that you're not allowed to use at trial a client's invocation of the right to remain silent.
Okay.
Mayor Sponger?
You sure may, in whatever order you want. I followed all that, and thank you, Mr. Shepherd.
Sure. So I'm going to start with the residual hearsay motion. I'm just going to reiterate what is what's put in the state's motion, but I do want to create a record in the presence of the defendant and his attorney. So while I know the state is well aware that the residual hearsay exception is rarely used except for exceptional circumstances. However, the courts have continuously allowed testimony from a victim's close friends and family about statements a victim made about prior difficulties. That's Ward v. State, 313, Georgia Supreme Court, 265. The pinpoint is 271. It's 2022 case. A victim's description of prior instances of abuse demonstrates sufficient guarantees of trustworthiness under Rule 807. The statements are given even more credibility when the circumstances in which they are made, particularly when the abuse is done in secret. So out of the line of sight of other individuals. Obviously, if the state had that testimony, we would be including that in its proffer. But that's Smart v. State, 299, Georgia Supreme Court, 414. The pinpoints at 423. In Wright v. State, which is the case I could find is the closest fact pattern to this one, which is 285, Georgia Supreme Court, 57. I believe the pinpoint starts on page 61. It's 2009 case. The court determined that the testimony from a grandmother of statements made by a 5-year-old child about a 5-year-old decedent child about the defendant inflicting injuries to her stomach were admissible as residual hearsay. The court determined that statements were trustworthy as the grandmother regularly cared for the child and was concerned about the child's welfare, creating the circumstances of the particular guarantees of trustworthiness to warrant admission. So in the circumstances around Mackenzie's statement, as outlined in the state's motion, they were made to her grandmother, her mother, and her aunt. First, the statements were made prior to any allegation of abuse by the defendant. No one offers this to Mackenzie as a way to explain the burn. She offers the word Mike. Second, the statements are made by a 1-year-old child who was asked directly, and this child denied any individual leaving the mark on her hand other than the defendant. The statements were repeated in front of multiple people, and she continued to identify the defendant as the person who left the burn mark on her hand. And they create sufficient trustworthiness as to the statement of Mackenzie Duffy regarding the prior difficulty. So on that basis, Your Honor, we would ask for those statements to be admitted. Now, moving to defendant's motions to suppress. So when we talk about the probable cause set forth in the 2 search warrants, so the cell phone records and the Uber records, the basis articulated by the detective was that he was narrowing down the number of individuals that were around this child when the fatal injury was inflicted. And he stated in his testimony that the defendant had given a version of events of where he was, what he was doing around when this child is deceased. That is a sufficient basis for probable cause to obtain both the warrants for the cell phone records as well as the warrant for the Uber records. He's not getting historical call site records for the entire month to show up that he was even at the apartment at the frequency that he states. He's specific about the time frame in which he is seeking to get those cell phone records. And the detective testified that he obtained that search warrant after the autopsy and during the course of his investigation. So there is sufficient probable cause to obtain that search warrant. As it relates to the single photo identifications, that I believe the defense has conceded that the IDs are proper. However, the courts have been very clear about when a witness is well acquainted or otherwise personally familiar with a suspect before making the out-of-court identification, there is not a substantial likelihood of misidentification. Although the courts have said that the single photo ID process is in fact inherently suggestive, but it's only improper when there's a substantial likelihood of misidentification. And when they're very familiar, there isn't that substantial likelihood. That's State v. Harris, 316, Georgia Supreme Court, 272. The pinpoint is 281 to 282. That's a 2023 case. It's actually tried here in Fulton County. The admission or the use of a single photo ID is also permissible when the detective is seeking to confirm the identity of a well-known acquaintance. And that's Lewis v. State, 314, Georgia Supreme Court, 654, pinpoint is 670. That's a 2022 case. Now, moving lastly to the defendant's statements, and I believe what the argument that defense counsel is making is that this phone call that the defendant is making to his mother, that there's some sort of reasonable expectation of privacy that the defendant should enjoy while sitting in a police precinct in a police interview. And what the state would point to is a line of cases that suggest otherwise. Specifically, the state points to Bergeson, that's Burgeson v. State, that's 267, Georgia Supreme Court, 102, the pinpoint is 106 to 107, that's a 1996 case, in which a recording device was placed in the back of a police car. And it was used to record the conversations of the occupants that were traveling that police car. And the court in Bergeson compared that very much to the other cases in that line, which is McKinnon, which is an 11th Circuit case, which applied that two-part test of did the person's conduct exhibit a subjective expectation of privacy? And then two, is the person's subjective expectation of privacy one that society is willing to recognize as reasonable? And that McKinnon citation, I don't have the first, it's United States v. McKinnon. I don't have the full citation in front of me, but the pinpoint is 527. And what we're looking at here is, and the reason why the state asked those very specific questions about whether or not this defendant asked to be taken to another location, or if he asked if the phone call was being recorded, because that does go to the subjective, reasonable expectation of privacy. He's in a police precinct, in a police interview room, using a detective's cell phone. There's no reasonable expectation of privacy that could ever be expected from a reasonable person in the same circumstances. The courts have continuously extended the rule in Bergeson, and there is a case that's somewhat on point. It's Rashid, it's Rashid v. State, 292, Georgia Supreme Court, 414. The pinpoint is 418 to 419. That's a 2013 case. And in that case, the state was allowed to admit a recording of a family meeting that took place in an interrogation room. And the state provided a transcript of that family meeting that took place inside the interrogation room. And that recording was permitted to be admitted. And the court said that there was no reasonable expectation for the defendant to have in a police interview room, even when he was speaking closely with his family members. Very similar to the circumstances that are before this court, with the defendant having that phone call with his mother in a police interrogation room. So we would ask for that recording to be admitted and not suppressed, although it was not particularized in defense counsel's motion. And we would ask for the motion to suppress the IDs be denied, the motion to suppress the warrants also be denied. Thank you.
Just briefly, Your Honor, we're not conceding anything.
No, understood. You said as much. You said you're not going to belabor the single photo ID now that you better understand the context. And the law with which I'm familiar is consistent with what Ms. McCauley said about that topic, the single photo ID. Okay, this has been very helpful. I think I have, once I get the thumb drive from Ms. McCauley, what I need to get an order out that should address what we need to be able to say, let's finally try this thing. And I want to talk about that. Mr. Shepard, you've been, I think, teaching, not going to, but teaching a class that interferes some or could interfere with scheduling things. I think that had come up more when we were working through some appellate stuff you had been doing in the past. Tell me, when I try to figure out when to set this down, are there things like that that recur? So first week of the month is better than second, or it's every Wednesday you're teaching?
Well, I was teaching. I am now taking.
Okay.
So I'm finishing up my doctorate,
Mhm.
and my classes this semester on Tuesdays, my classes next semester on Thursdays. Trials during the breaks are the best. I am going to give up my class going if it's a trial. I'm trying not to give up classes for a status or an inquiry.
Sure.
Or pointless court appearances. There are some that are more important than others.
Okay. Trial would fall in the category of pretty important.
Yeah, so.
Okay.
But I'm trying to make as many classes as I can.
Sure.
And this will be for the next 4 years.
Oh, okay. So this is not just, if we can get past this semester, it's many more semesters.
1 class per semester, 2 classes per year, 8 classes.
Got it.
But once again, I've got a murder trial next week. So the Say O'Neill hearing, I probably won't be here for that.
Oh, okay. Well, let's work with Ms. Nelson, and that's one we need to get onto your calendar, but trial is certainly would take precedence over that.
Yeah, and he's not likely to bench warrant since he's in custody.
Yeah.
The other one bench warrant, but no, this is a murder trial. It's going out. You may know our judge. Her name's Dia Warren.
Oh, yeah. Okay.
It's specially set for Monday, and I
Okay.
don't think anything can stop this trial from happening. I talked with the state's attorney, and we've both agreed that, unless the building burns down, we're having this trial.
Well, let's hope that doesn't happen.
Oh, I didn't mean to suggest it, but
Yeah.
no, it's one of those that's going to happen. So I probably won't be here for the Say O'Neill hearing.
Okay. Ms. McCauley, back when there was a different lawyer working with Mr. Reynolds, we had specially set this at your request. Does that remain? And I can't remember if that was because your schedule's crazy or there are enough moving parts or maybe out of town witnesses because so much time has passed. People have moved from Georgia that a special setting was just the right way to structure it so you could ensure you got your witnesses here.
I do have a number of professional witnesses, one being Detective Sludge, so I was a little concerned about it being called in November because he's out till November 17th.
Yeah, that just came up in a Judge Emerson case.
So that was a concern for the state. I have another professional witness that I do need to be a little conscious of her scheduling. It's Mary Beth from the Georgia Center, as well as the doctor, the emergency room doctor. And possibly Dr. Messer, but he's listed an issue. So that would be the state's preference. I'm actually just trying to access. I am specially set before Judge McAfee on.
He now has all sorts of time.
He does, but we, there's a specially set trial in his courtroom, December 11th, I believe. It's December 11th or December 14th.
Okay.
And so I noticed that it's December 11th. I noticed that this case was possibly set down for the December 1st calendar call, that's what's in the system. So preparing to, one, be available the week of December 4th, to try this case, but then also being able to handle the trial that comes the week after. Actually, Mr. Jordan's, we're on the same 2 cases together.
Got it. Okay.
That's the way the universe works, because my final exam is on November 28th. I cannot miss that day.
Right.
And I was going to suggest the first week of December, because that's between classes. Classes start back up again on January 8th.
Right.
Especially say on a co-defendant homicide in Richardson.
That's how the universe works.
So you're specially set with Judge Richardson when?
January.
Oh, okay. But the week of December 4th is in fact a week of trial for me. Your concern was you've got the McAfee trial the week after.
Yeah, but that's fine, Judge. If I know about it now, it's fine.
Okay. Let me get with Ms. Nelson about that. I want to make sure we haven't oversubscribed.
My concern is that if you were doing another trial with perhaps Mr. Abate in November, that there might be bleed over to.
Right, but we would know that well in advance. So yes, this is currently on final plea for November 7th, and then on the trial calendar that's called on December 1, but would begin on December 4th. So let me talk with Ms. Nelson about that. If we did specially set it, that is post-exam, it is pre-McAfee. And if the case with Mr. Abate and Ms. Clark Palmer actually goes forward, I would know that on November 8th. That's far enough in advance that I could cancel the special setting, and that wouldn't, I mean, people wouldn't burn up airfare or anything like that. Okay.
And then the mental health aspect of having to deal with Mr. Abate and me right afterwards, might want to factor that in.
I'm immune to that now.
December 4 is perfect.
Okay. All right.
For me, I don't want
It's fine.
This case has been waiting so long. Something that is near perfect, I'll take. And so I don't like stacking back to back for Ms. McCauley, but otherwise we're deferring a case that it should have been addressed long ago. Again, not the state's fault, not Mr. Shepard's fault. We had a number of transitions for Mr. Reynolds, not Mr. Reynolds' fault either. I'm not blaming anyone. They cycled through too many conflict defenders. Why was it a conflict defender case to begin with?
I have no idea.
Who knows? That's lost in the sands of time. Okay. All right. Well, Mr. Shepard is keeping.
Fulton C3 project exists.
Yeah.
Because they play a Ponzi game over there. I used to work over there. I know the Ponzi scheme well.
Okay.
And that's why it was so smart for Fulton County on some cases to say, we're just going to use internal funds.
That super smart Fulton County every once in a while gets it right. Okay. Ms. McCauley, anything else in the Reynolds matter? Okay. Anything else, Mr. Shepard?
Yeah, just to warn Ms. Rivers that she'll be getting my normal request for the transcript.
Okay.
And if there's any way we could get it before December 4, that would make my life.
Okay. I'll let you and Ms. Rivers talk about that, and then she'll let me know. Why is it all broken?
I don't know. That was the one that was available to me
Okay.
today. So.
All right. It's okay.
So just last question, what are we going to, I will know if the trial starts on Monday, and are we going to reset, say O'Neill?
Oh yeah, we'll have to reset. If you're in trial, we have to reset it. Is that,
on Wednesday or Thursday?
Go back one. Yeah, so yes, that's Thursday, the 26th. So what I'll do is make sure Ms. Nelson confirms with Judge Warren's crew. If you're going out, I'm assuming that will take you through Thursday and beyond. Okay, so we'll confirm on Monday that went out. And if it did, we will have to reset O'Neill. I think Carlisle, we're done with Carlisle. It was just the severance piece. I've ruled on that. So with you, it was, I think, identification. It's whatever it is. We will go through it. It just can't be that day if you are in Douglas County for a while. Okay, got it. Thank you for flagging that. Mr. Reynolds, any questions for me?
No, Your Honor.
You follow what we're talking about?
Yes, Your Honor.
Okay. Thank you, everyone.
Thank you, Your Honor. You have a great weekend. Thank you, Warren.
Can I go?
You're welcome.
You're free
Yes.
to go today,
I'm just gonna ask that the.
all the way to November 7th. November 7th. You need for anything else of that?
No, I think, you're welcome. I lost it from your former client.
I heard. You know, one of all my former clients, he's not my favorite.
I know,
You
he's
know
not
who
your
my favorite.
Who's your favorite?
Come on.
Oh, yeah. Oh, so we were supposed to go, and then Brian Hobbs got a trial in, what's it called, in Cobb's. We were taken out because we were supposed to go first week of November. She's awful, but you know what, do you know how awful that is? Our wives took that video down to the medical examiner's office and showed it to the medical examiner, and she's like, well, these aren't the fatal blows, that must have happened in the bedroom, and now we have to re-indict her, their client, Jeff Myers from Mount murder, because he's in the bedroom with her the whole time.
Thank you, sir. You learned that the Fulton C3 tried to give me that case back.
What, really?
Yeah.
But I thought you liked the Fulton C3.
No, I like Brian on that case. He's great.
No, when I was working for the GBDC, they assigned me to Kirsty Flood. And she was just horrible to me. And then I went to work for the appellate division, and they got reassigned. And then the first case the Fulton C3 tried to give me was that one back. And I was like, that client hates me.
Can't do
Yeah,
that.
she doesn't like Brian, I heard.
I don't think she likes anybody.
No, she liked the one that asked me for involuntary manslaughter.
Well, the John Hunter one, I'm gonna be interested to see how that case.
I
turns out.
might take the rape on him and just go on the conspiracy count.
So I would do.
Yeah. But there's some new evidence on that.
I mean, the rape is weak on him.
Yeah, I know.
That's why we have trials.
I actually offered them all, I got a global from Bonnie Smith down in Clayton. He has 2 open cases down in Clayton, and I got Bonnie to agree to a global for 7, and he said no.
I knew about those cases all along. I wasn't gonna tell you.
That's all right, I already GCSE.
I was
Just on a whim.
Yeah. Benny Wilson, but no, he's by far not my favorite. He left me alone.
Yeah.
And he was always polite to me.
He's been, I mean,
Does he just speak to her?
no,
Yeah,
but
first he was something special.
she is something special. That trial's gonna be brutal.
Is that still Emily Richardson?
Yes, it is. Thanks, Judge. Have a good afternoon.
Yeah.
You guys too.
I'll be honest with you, I do get the occasional difficult
It's
cases.
just got a murder in one instance.
Pardon?
Murder in one instance.
That's Judge Whitaker's, 3 defendants.
Is it?
Yeah, Emerson is in her courtroom. And so she was down there because she said she didn't, hold on one